Good morning, everyone, and welcome. My name is Alvina Earnhardt, and I am the chair of the Colorado Advisory Committee to the U.S. Commission on Civil Rights. And this briefing on the backlog and naturalization applications in the U.S. Citizenship and Immigration Services shall come to order. For the benefit of those in the audience, I will allow my colleagues to introduce themselves by saying their names and where they reside. So we'll go ahead and start to my right and work our way down.
William Perry Pedley.
Eve Muniz Valdez, Pueblo.
Ming-Sue Chen, Boulder, Colorado.
And again, I'm Alvina Earnhardt from Milliken, Colorado.
David Copel from Boulder, and so I really appreciate how much the free parking mattered today.
Helen Rowley from Littleton.
Will Trackman from Denver.
Okay, also present are the U.S. Commission on Civil Rights staff, Barbara DeLevy to my left, and Evelyn Bohar, and I believe she's outside in welcoming everyone here today. Okay, the U.S. Commission on Civil Rights is an independent bipartisan agency of the federal government charged with studying discrimination or denial of equal protection of the laws because of race, color, religion, sex, age, disability, or national origin, or in the administration of justice. The Commission has advisory committees in each of the 50 states and the District of Columbia. These committees are comprised of volunteers who serve without compensation to advise the Commission on relevant information concerning their respective state. The purpose of today's briefing is to hear testimony on the backlog in naturalization applications in Colorado. This briefing could not come more timely. We know that just last week, on February 12th, the House Democratic Caucus sent a letter to the U.S. Citizenship and Immigration Services Director, Lee Francis Cisna, to express their grave concern about the alarming growth in processing delays at USCIS and requested a prompt response to detailed inquiries that they raised in their letter. We are fortunate to have a full schedule of panelists who will share with us their expertise at this briefing. I would like to present the ground rules for today's meeting. This is a public meeting, open to the media and the general public. There is a court reporter, and we are being live streamed. We have scheduled panelists who will provide testimony within the time available. After all panelists have concluded their statements, committee members will engage them in questions and answers. To accommodate persons who are not on the agenda but wish to make statements, we have scheduled an open session at the end of the briefing today. If you wish to speak, please add your name to the list at the registration table outside where you came in. Please note that the open comment period is not an opportunity to ask questions of the panelists, but rather an opportunity to express your concerns and opinions regarding the backlog in processing naturalization applications. In addition, written statements may be submitted by mail. Please see a staff member for the address. In order to ensure that all aspects of the issues are represented, knowledgeable persons with a wide variety of experience and viewpoints have been invited to share information with us today. Though some of the statements made today may be contentious, we want to ensure that all invited guests do not defame or degrade any person or any organization. Any person or any organization that feels defamed or degraded by statements made in these proceedings may provide a public response during the open comment period. Alternately, such persons or organizations can file a written statement for inclusion in the proceedings. I encourage all persons making presentations to be judicious in their statements. The Colorado Advisory Committee appreciates the willingness of all participants to share their views and experiences with the committee. I would now like to begin our meeting by introducing the first panel. Today we have Diego Iniguez Lopez with the National Partnership for New Americans. We also have Nicole Malacu, who is the Executive Director for Colorado Immigrant Rights Coalition, and Travis Weiner with the Colorado Chapter Lead, Veterans for American Ideals and Veterans for New Americans. So I believe we'll go ahead and start with each of you having at least 15 minutes to present, and we'll go ahead and begin with you, Diego.
Good morning. It's an honor to be testifying today before you all. I'll be speaking to you today about the backlog of citizenship applications, processing delays, a series of policy changes that limit access to citizenship, and steps that we could all take, including this committee and the larger commission. I'll be speaking on behalf of the National Partnership for New Americans, or NPNA, a multi-ethnic, multiracial partnership consisting of 39 immigrant and refugee rights groups in 31 states. Our members provide large-scale services for their communities, from submitting citizenship and DACA applications to voter registration to healthcare enrollment. They combine these services with sophisticated organizing tactics to advance local and state policy. We believe this nation's success is rooted in our ongoing commitment to welcoming and integrating newcomers into the fabric of our nation and to upholding equality and opportunity as fundamental American values. As such, we appreciate the Commission's hearing on citizenship backlogs. We believe that the backlogs implicate issues of discrimination and unequal application of the law, and in doing so, undermine those American values. When MPNA talks about the hundreds of thousands of eligible lawful permanent residents stuck in the backlog, and when we talk about the almost 9 million residents who are eligible for citizenship but have not applied, we understand that we're talking about beloved family members and friends. These community members of ours originally came here in search of a better life and opportunity. They've been part of our communities for decades, and they work hard for their dreams and that of their families. They should have access to citizenship and the benefits that come with it, including the ability to maintain family unity. This is protected by the Constitution and federal laws. That Constitution and the laws that flow from it require fair and equal treatment and institutions that are accountable to the public. That is what makes this country strong, rich, and diverse, and that is what makes us live up to the national values of community, opportunity, and equality. A major threat to those values is the backlog of citizenship applications pending before U.S. Citizenship and Immigration Services, or USCIS. According to the most recent data released by the agency, they have over 750,000 citizenship applications pending. This has almost doubled since late 2015, when the backlog stood at around 388,000 applications. The majority of this increase occurred during the current administration. At the current rate, it would take USCIS at least 25 years to get back to the Obama administration's level of around 380,000 applications in 2015, if no new applications are filed. MPNA believes that the backlogs indicate malevolent incompetence by USCIS leadership designed to disenfranchise aspiring U.S. citizens. In August 2018, we filed a Freedom of Information Act request to uncover the reasons for the backlog, which we suspect are discrimination based on race, ethnicity, religion, and national origin. On September 17th, Citizenship Day, we filed a lawsuit based on a lack of response represented by the Center for Human Rights and Constitutional Law and the Coalition for Humane Immigrant Rights. We are hopeful that through this litigation, we'll start to learn the reasons for the backlog, and we once again urge the agency to be transparent. We are also encouraged by an announcement made yesterday by Representative Zoe Lofgren, who is the chair of the House Judiciary Subcommittee on Immigration and Citizenship, that she intends to hold hearings on this very issue. We respectfully request that this commission help us move towards accountability for USCIS. In addition to examining the cause for the backlog, that should include also scrutinizing USCIS's plan, if any, to create detailed models and procedures to substantially reduce the backlog. We know that we need to know what the timeline is for the plan and its metrics for success. USCIS has substantially reduced backlogs in the past, and if there is a political will, they could do it again. If they don't have the political will, then we are concerned that there's going to be a lot of explaining, rationalizing, and creative redefinitions of what the backlog is and what it isn't, and that any plans will lack follow-through and the needed results. There are over 750,000 immigrants who are stuck in the backlog, and they deserve fair and equal treatment from USCIS. And the agency needs to be more responsive in addressing and overcoming its failures. So we respectfully request that this committee move us in that direction by issuing statements against the backlog, as well as raising this issue with the larger National Commission. Related to the backlog is the issue of processing delays of citizenship applications. The delays in processing have also increased, almost doubling since 2015, reaching crisis-level delays, according to the American Immigration Lawyers Association. The national average processing delay is about 10 months. Almost all of the USCIS field offices have delays that exceed a year, with dozens of offices nearing or exceeding 2 years. In the worst case, some jurisdictions face processing delays that exceed 30 months. In a growing number of cases, we are starting to see that the delays are so long that eligible residents who have already applied risk not being processed and naturalized in time to be able to register to vote in the presidential elections of 2020. Think about that for a second. We are in February 2019, and a process that previously took under 6 months is now so long that people will not be able to go through it in time to vote in the next election occurring in 21 months. As of February 20th, according to USCIS and their estimates for processing delays, this risk exists in Miami, Atlanta, Houston, Dallas, Las Vegas, Reno, Memphis, Minneapolis, St. Paul, Montgomery, Newark, New Orleans, New York City, Philadelphia, and Washington, D.C., among other cities, and this risk will arise in other regions as the year progresses. Backlogs and processing delays have reached such crisis levels that they effectively serve as a voter suppression tactic. Residents, people who have been here for years, raise families, who are eligible for citizenship and all of the benefits that flow from it, who have paid $725 to an agency that serves the public, who have followed a process created by our traditions and laws, they are being blocked by a second wall that limits their access to not only citizenship, but the rights that come from it and the benefits that come from it. These benefits include access to better jobs, higher rates of home ownership, protection against the aggressive immigration enforcement of this current administration, and the ideals of an active and civic population in this democracy. I'm speaking before the Commission on Civil Rights, so I need not detail how access to jobs, home ownership, discrimination from enforcement agencies, and the ability to vote has long been marked by racially based exclusion against African Americans and comprise some of this country's lowest historical points. This, along with the history of when the federal government used naturalization laws to exclude people based on race, ethnicity, and country of origin, make us very concerned with the backlog and processing delays. As part of our response, MPNA, our member organizations and partners, have launched a campaign to encourage eligible residents to apply for citizenship in order to motivate 1 million citizens by 2020. We will continue to combine these efforts with condemning and organizing against the backlogs, processing delays, and other barriers to citizenship. Over the last 2 years, the current administration, in addition to skyrocketing backlogs and delays, have proposed and implemented a series of policy changes that limit access to citizenship. They include the proposed regulation on fee waivers, which would limit access based on wealth and class and disproportionately impact elderly and working poor immigrants. The proposed regulation, if implemented, will cut off access to citizenship by removing the receipt of a means-tested benefit as a basis for receiving a fee waiver for the citizenship application. The proposed regulation could impact up to 244,000 immigrants who are eligible for citizenship, but if implemented, could simply not afford it. Another proposed regulation is one that will revise the application form, the N-400, adding questions that, if implemented, will prompt unnecessary, irrelevant, and duplicative information from applicants. For example, applicants will now be required to submit birth certificates of their children with their N-400, which is not currently required. This is an unnecessary burden that will be a bureaucratic annoyance for immigrants from places like Norway, but difficult, if not impossible, for refugees from places like Syria or Somalia. The revisions, if implemented, will make it more burdensome for applicants, their legal representation, and the agency adjudicators themselves, and is going to further discourage eligible residents from applying for naturalization. There's also the new policy guidance, which went into effect on February 12th, related to the Form N-648. This form allows an applicant to request an exemption from the English and civic testing requirements based on a disability. These changes would make it more difficult for eligible residents with disabilities to apply by requiring that the form be filed with the citizenship application as opposed to submitting it during the interview, which was previously allowed. It also directs officials to suspect applicants of fraud if they do not submit the form with their citizenship application, even though the form requires a certification from a licensed medical professional under penalty of perjury and could take longer to obtain, thereby delaying even the submission of citizenship applications, let alone processing times. The backlog, processing delays, and policy changes within USCIS strongly suggest that the agency is moving away from its mission of serving the public. They strongly evidence that the agency is becoming more and more a critical part of the current administration's enforcement agenda and constant attacks against immigrants and refugees. The agency's dedication of unprecedented resources to denaturalize citizens who have been naturalized for years, if not decades, confirm this. This is further evidenced by 2 sets of policy guidance from last summer that expand the circumstances in which officials commence deportation proceedings against applicants who are applying for benefits and direct agency officials to deny applications for benefits instead of requesting additional information or sending out a notice of intent to deny. We're not talking about a limited set of policies. We're talking about the processing of citizenship applications and USCIS being used by the current administration to target immigrants independent of their immigration status. Before concluding, I would like to acknowledge that in understanding the backlog, which is what this panel is about, there are some causes and trends that we could point to, such as processing delays that exceed 2.5 years, the lack of proper resource allocation, increased requests for evidence, or RFEs, arbitrary, invasive, and irrelevant questioning of applicants. These attacks on access to citizenship help us to understand the backlog and the role of USCIS as part of the administration's aggressive agenda against immigrant communities. There are, however, some critical things that we do not know and that we're trying to uncover through our FOIA litigation and through increased congressional scrutiny. This includes any communications between White House officials and USCIS leadership related to processing citizenship applications, USCIS's allocation of funds to different facilities and field offices, instructions and directives by USCIS headquarters on the processing of applications, and the extent of complaints by applicants because of discrimination, abuse, or inappropriate treatment. These lines of inquiry are important to note because they can reveal whether USCIS is applying special scrutiny because an applicant has a particular race, religion, or national origin, or because they happen to live in a state that leans politically towards the Democratic Party, or they live in a purple battleground state. They can reveal the degree to which USCIS issues RFEs that are unreasonable and not related to a citizenship application. They can reveal whether certain groups of immigrants are subject to extreme vetting, and what are the factors at play in the agency's decision to launch a new office dedicated to denaturalizing citizens. There are questions that this committee can help us to answer through public pressure and through the larger National Commission and its investigatory and subpoena powers. These causes for the backlogs will take longer to fully comprehend, but citizenship is a priority issue for our members, so MPNA is in it for the long haul. And we believe that through a broad coalition of our member organizations, partners, cities, mayors, and entities within the federal government interested in the protection of civil rights, such as this one, we can start to address this issue in its entirety and hold USCIS accountable and compel the agency to be transparent with the public. In the meantime, we cannot be discouraged. We can and should encourage our family, friends, and neighbors who are eligible for citizenship to apply as soon as possible and work together to mobilize 1 million individuals to become citizens by 2020. So I invite you all to be a part of this effort. Thank you very much for the examination of this issue and for the opportunity to speak.
Thank you, Diego. We'll be asking questions once we finish the full panel today, so we'll go ahead and start with Nicole, if you're ready. Thank you.
Great. Thank you so much for having me. I'm here representing the Colorado Immigrant Rights Coalition. We are a coalition of 94 organizations representing faith, labor, grassroots, and other community-based organizations who are working to promote fair and just immigration reform and state reform to improve the lives of immigrants and refugees in Colorado. We do our work through policy, advocacy, and nonpartisan civic engagement. The work of naturalization for CIRC is incredibly important. We see naturalization work and citizenship as really the pathway and the starting point for civic integration of new Americans. And as a founding coalition of part of NPNA, we have built deep structures across the country and in Colorado to be able to meet the demand for naturalization over the last several years. I want to start by saying that the work of providing citizenship services to community members is incredibly difficult. For one, there are a lot of ways that there are automatic barriers for people to access naturalization, and that includes having low income, not being able to apply for the naturalization fee. Many folks work 2 jobs, so we talk a lot about the working poor in our work and people who are unable to access naturalization. And then third, the things that I'm here to talk about are really the community perspective. So many folks, and especially under the Trump administration, see potentially an engagement with USCIS as an opportunity for them to be ensnared by deportation operations. And so we have a few cases that have popped up in Colorado where individuals went in for their USCIS appointments and were actually intercepted by ICE in the process and were actually put into proceedings. So one case in particular, Melesio Anzaldoa, last November was actually one such case, and his adult daughter was petitioning for citizenship the legal way, as people say, when you can get in line. And what happened is that his application basically tipped off the process for deportation when he had already been approved for a green card. So under the Trump administration, we are seeing, and we have seen, many cases where folks, as Diego mentioned, are now becoming under duress and double scrutiny by immigration enforcement. So it appears from the outside that folks who are submitting their N-400s at this moment are being double screened. Not only have they been screened through the green card process, but then once again during the adjudication process. We are also incredibly concerned on the ground about the wait times. As Diego mentioned, we are calling our campaign the second wall. We feel this is an intentional effort by the current administration to stall the process of naturalization for new Americans, thereby limiting their full participation in civic engagement. We know now that the processing time for any application for a new American who would like to vote in the 2020 elections needs to be completed by May 2018. In the past, CIRC and our member organizations have assisted people, and the wait time has been less than 6 months. 2015, I was personally in charge of our citizenship campaign, where we assisted over 3,000 lawful permanent residents with their naturalization applications, and within 6 months, 85% of those participants had already gone through the process, whether they were, most of them approved, but most folks had been contacted within the first 9 weeks for their biometrics and their USCIS interview. In 2016, we assisted over 1,500 individuals, and the wait time was slightly longer, working toward 9 months. In the current environment, we are seeing that our applications are averaging the 18 months. And so we on the ground, not only do we have an incredibly difficult time to be able to educate the community on the benefits of citizenship, but then to actually feel like there is an intentional effort to discourage people from the process by the long wait times. It is increasingly clear to us that this is an assault to our democracy. When people are ready to finally take this step, they need to trust the process and know that USCIS is adjudicating their application in a fair and timely manner. As we all know, so when we have folks that applications are not arrived in time or processed in a timely fashion, they aren't able to participate in upcoming elections. And for many folks who have decided that this is the country that they want to continue to call home and create their lives, that they're ready to take that next step and vote in our future elections. And clearly, this is an effort to undermine that. We have heard stories of folks who are unable to apply for higher paying jobs. And we've also really heard on the ground of instances where folks are really concerned about deportation for little offenses like a minor traffic speeding ticket or those things. And so as a precautionary measure, we are having all of our applicants include their driving records for minor traffic infractions so that they are not adjudicated unfairly for not including that on their naturalization application. As Diego mentioned, the fee waiver continues to be an area of discussion for many folks that come forward to apply. One of the first questions on the floor when we are processing applications is if the fee waiver, petitioning for a fee waiver makes them less attractive to USCIS to approve those applications. So there's anecdotal data and community data that petitioning for a fee waiver is actually going to make you a less attractive candidate to get to the interview process. As we mentioned, the backlog is very concerning for the community and the organizations that serve community because of the fact that we spend so much time in community educating folks about the benefits of naturalization. And then the broader narrative outside of our movement and our network is that these folks are unwanted in our democracy, and therefore these barriers are coming up as an intentional effort to be able to undermine full civic participation of new Americans. Here in Colorado, the backlog of naturalizations or eligible folks who are eligible hovers at around 90,000. And every year it is our charge to help naturalize at least 6,000 of these folks through our networks, but we know that's not nearly enough capacity on the ground to do this. The other point I would like to mention is there is an element of psychological demoralization that's happening in community as a result of the backlog and the fear that this process has created. Many folks are coming forward, and we've seen a rapid decline of workshop participants. So in the past, we could turn out close to 200 individuals for a low-fee citizenship workshop, and for $35, people could come forward. And so the target for these type of services is typically the working poor, who otherwise would be paying $1,500 for a regular legal service appointment. We have seen attendance decline rapidly by almost 50% in field. And so we are deeply concerned that the external narrative and the barriers that are being created are really inhibiting communities' understanding of the benefits and the community partners who are willing to support people in their naturalization journey. We feel strongly as CIRC that when people are ready to take this important step to be able to fully integrate into our democracy, that their applications that are funded by service fees within USCIS will be met with fair adjudication and timely processing. And so the current status of the backlog is really in direct opposition to that, and we thank the Commission for oversight into this. And of course, we'll continue our work with the Partnership for New Americans and all of our other partners to increase naturalization education across community while we continue to look deeply at the barriers that are being put up within the current administration. Thank you.
Okay, thank you, Nicole. And we'll continue on with Travis Weiner. Travis.
Thanks, Chairman Earnhardt. Veterans for American Ideals is a nonprofit based out of Washington, D.C. with chapters in most of the states. It's a subset of Human Rights First. Essentially, what the organization is about bringing together veterans from all walks of life, all political and religious persuasions, but they unite around a common understanding that there are certain American ideals that are nonpartisan, and we reject the partisan label, and we advocate for those ideas. And one of those certainly is military naturalization in the context of service in the U.S. military, which is about as fundamental an American ideal as one can imagine. And that's what I'm here to talk about today. I'm here to talk about naturalization in the context of military service members and veterans, some troubling changes to the procedures for naturalizing these folks, and finally the crisis of deported U.S. military veterans. One can't separate these issues, and one cannot separate the backlog from the denials and from the increased barriers to naturalizing, whether that's with veterans or whether that's with civilians. So I'd like to start with some background on immigrants in the U.S. military. They play a vital role in our military. An estimated 40,000 served in the year 2015, and about 5,000 non-citizens enlist in the U.S. military each year, although that is declining rapidly for reasons I'll get into. However, approximately 95,000 immigrant veterans do not have their U.S. citizenship. The U.S. currently is home to about 510,000 foreign-born veterans. However, of these, only about 415,000, or roughly 80%, are actually naturalized citizens. The remaining veterans have yet to naturalize with no access to the rights and opportunities conferred by U.S. citizenship. And again, these statistics bear on some of the issues that I'm going to be talking about. Immigrants in America have served in the military with particular distinction. Over 700, or more than 20% of the 3,500 Medal of Honor recipients have actually been immigrants. Citizenship for military service was well established in this country and frankly in ancient times, in ancient Rome. In the Revolutionary War, countless non-citizens fought with the promise of U.S. citizenship once the new country was formed. The Civil War saw the first expedited service to naturalization pathway codified in law, and it allowed service members who were veterans to receive expedited naturalization following their service. The practice has been in place for hundreds of years. From the years 1862 to 2000, 650,000 non-citizens naturalized through U.S. military service. And indeed, let's not forget that non-citizens are subject to the draft, and in the 19th and 20th centuries were drafted to fight this nation's wars. So I'd like to talk a little bit about the basics of military naturalization and how it works, and then how, the changes that we're looking at right now. Federal law provides that certain members of the U.S. Armed Forces have the opportunity to apply for expedited naturalization. The vast majority of the time, with scant exception, these individuals have to have legal status to enlist in the first place. Essentially, what expedited citizenship waives are the continuous presence and continuous residence and physical present requirements, as well as a substantial filing fee. Under INA 328 for periods of peacetime and INA 329 for periods of hostility, along with the implementing regulations and executive orders from the Bush administration, individuals who served honorably during a period of hostility can apply for naturalization once the Defense Department certifies that individual's service as honorable. The U.S. has been in a period of hostility since September 11th, 2001. And since then, over 100,000 service members have naturalized through these expedited procedures. For service members to qualify for expedited citizenship under INA 329, the Defense Department must first certify their service as honorable. And they must complete U.S. Citizenship and Immigration Services Form N426, request for that certification, and then they must submit that form and an N400 to a USCIS office, which processes that application. However, in October of 2017, the Defense Department, at the direction of the Trump administration, implemented 2 key policy changes to this process, which myself and others believe are strongly to blame for the declines in the rates of naturalization. And those are, firstly, the background screenings. So as of now, non-citizens, including green card holders who seek to enlist in the U.S. military, must complete additional background screening requirements and receive a favorable screening prior to attending basic training. So before then, those who were eligible could enlist in the military. They were allowed to start as long as this additional background training had begun. But the effect of this change is that the process can take a year or more. There is a backlog of more than 700,000 cases. And the effect of this change is that non-citizens who join in the military may be stuck in this background process for so long that they overstay their visa and they may be subject to removal. Like so many other Trump administration policies, there is scant evidence for this. Indeed, these individuals went through security screenings first to achieve legal status, and secondly, the same security screenings that everybody who seeks to join the military goes through. The second change was the implementation of a completion of 180 days of service before receiving that honorable certification. So now, non-citizens must complete 180 consecutive days of service, and the secretary of each military branch must characterize that member's service as honorable, must personally sign off. However, there is no current procedure in place to obtain this signature. So this is analogous to the Trump administration's fictitious waiver procedure under the third travel ban, stating a procedure when in actuality there are no regulations, there's no process to get this certification. We have evidence of individuals in the Defense Department and the Trump administration on record making certain claims for why these changes exist. So this is from an Army Times article. The Pentagon's announcement last year as to these changes quoted Stephanie Miller, Director of Military Ascensions. While the department recognizes the value of expedited U.S. citizenship achieved through military service, it is in the national interest to ensure all current and prospective service members complete security and suitability screenings prior to naturalization. This individual was the author of the memo that essentially began this process. But again, as I mentioned, this ignores the fact that those enlisting already have legal status, so there is a significant security screening that has already happened, and it ignores the fact that everyone who enlists undergoes a standard security background check, whether citizen or not. This is a solution that is in search of a problem, and through court cases that I'll mention later, reeks of pretextualism. So the recent declines. Between October 1st, 2001 and September 30th, 2017, more than 125,000 military service members naturalized. In fiscal year 2017, USCIS conducted 7,300 U.S. military naturalizations. That was a decrease of 16% compared to fiscal year 2016, and well below the all-time high following World War I in 1919 of 130,000 U.S. military naturalizations. More recently, military naturalizations have plummeted. They've dropped almost 65% in the first quarter of fiscal year 2018 compared to the fourth quarter of fiscal year 2017, plummeting all the way to 755 naturalizations from almost 2,200 in the previous quarter. At the same time, the rate of military naturalizations denied by USCIS increased from 10% in the fourth quarter of fiscal year 2017 to 25% in the first quarter of fiscal year 2018. This drop in military naturalizations and increase in the percentage of denied applications came after the Defense Department's policy, which I spoke about. This policy change has already had a very tangible effect on military and veteran naturalizations, limiting the number of those who can apply. The most recent USCIS data indicates that the recent drop in military naturalizations is unlikely to abate. They dropped 57% in the first 6 months of fiscal year 2018 compared to the previous 6 of fiscal year 2017. I want to talk about a program called MAVNI, which some of you are familiar with, including its cancellation and the resulting lawsuits. This program was designed to recruit non-citizens with essential skill sets to use in the fight in the war on terror. Language, communications, technology, medical expertise were preferred. However, in 2017, the Pentagon began to make the initial decisions about suspending the program, citing security concerns and vetting concerns. This stated desire to halt, either temporarily or permanently, the program, despite the fact that there had been not one documented instance of a recruit joining with the intent to commit an act of terrorism, startled the nation's preeminent experts in the service to citizenship pathway. Professor Margaret Stock, perhaps the nation's preeminent expert on military naturalization, remarked, "They're subjecting an entire group of people to extreme vetting, and it is not based on any individual suspicion of any one person. They've already passed all kinds of security checks already. That, in and of itself, is unconstitutional." It's unclear whether the Pentagon understood how or whether this would deter immigrants who, at least outside of MAVNI, were not more likely than not to enlist. Professor Stock elaborated as to whether the Defense Department's suspension was temporary or permanent and its implication for future enlistments of non-citizens. The latest memos, including the one I spoke about, that the Defense Department has ended the program permanently since the program can't function with these new rules, means that no sane or rational immigrant would enlist under the new rules that the Defense Department has imposed. I'd also like to speak briefly about our wartime allies as they are on the path to naturalization. The first regards the Special Immigrant Visa Program for Afghanistan, which allows individuals who served with coalition forces and risked their lives and their families' lives to apply for a special visa as a reward for their service to come over to the U.S. About a decade ago, there was an annual allotment of 5,000 to 10,000 visas. However, recently, including this year, these visas have not been included in the annual appropriations of Congress. Not only that, but there's a class action lawsuit from the Immigrant and Refugee Rights Coalition out of New Jersey that alleges that the State Department and the Department of Homeland Security are sitting on applications and not processing them in a timely manner as required by law. In addition, with regards to Iraq, there's a special program called the P2 program, which allows individuals in Iraq who are in the same category as those individuals in Afghanistan to apply to come to the U.S. as refugees. They can do so from Iraq. They don't have to leave. In fiscal year 2015, we admitted over 10,000 of these refugees. The State Department estimated that in fiscal year 16 and onward, we would admit up to 10,000 to 15,000. As I mentioned, the numbers are pretty low this year. In this fiscal year, we have admitted less than 200. These are individuals that would be on the naturalization pathway. And finally, with regards to deported veterans, as I mentioned at the beginning of my remarks, I believe that you really can't separate the issues of military naturalization, declines, backlogs, and then you come full circle to the issue of deported veterans. Unfortunately, the Defense Department and the Department of Homeland Security does not track the number of deported veterans. To get an estimate of how many there are, we rely on organizations such as the Texas Civil Rights Project, the ACLU, and other organizations that have conducted white paper studies on this issue. We know for a fact that there are many hundreds, and there could be over 1,000. There are many reasons for this, but some that I want to highlight for the Commission are a lack of uniformity among the services and Defense Department. So I talked about the laws with regards to naturalization of military service members, and it's great that our immigration laws allow for this expedited naturalization. However, there are serious gaps. And one of those is that each service does this differently. One military base and one military service might provide significant naturalization assistance to a service member. The next might say you're totally on your own. And we've encountered this in interviews of these folks. There's a lack of USCIS facilities near every military base. There was a pilot project to try to have a naturalization office at every post. That's ended, and in fact, some have closed down. There's also a lack of information and affirmative misinformation. We've seen instances of recruiters telling folks that once you take the oath of enlistment, you are a citizen. That's not true as a matter of law. We've interviewed individuals whose chains of command have told them, don't worry about it. You may be transferring overseas to Korea. Don't worry about missing your naturalization interview. Those individuals have been removed following their honorable service, oftentimes for minor crimes. There's also some serious government failure. In the ACLU report, they've documented numerous instances of lost or misplaced naturalization applications. They've also documented that when these veterans were put into removal proceedings, over 70% had no attorney present. This despite the fact that ICE has internal memoranda from 2004 and 2011 that state that in order to place a veteran into removal proceedings, they must obtain the signature of the special agent in charge of that ICE office. ICE routinely violates this requirement. So in closing, what I'd like to say to the Commission is that civil rights as a matter of law under our Constitution and Supreme Court precedent do not require that individuals be U.S. citizens. Civil rights apply to non-citizens and citizens alike. When we combine everything I've discussed with the new phenomenon of naturalization application declines, canceling of N-400s, and we see that this is not based on any credible evidence, what I would urge this advisory committee to ask are these questions. Is this backlog, whether for the military veterans or civilians, ideological in nature? Are there good faith reasons why denials are on the rise and the backlog is so severe? Or are these phenomena a result of ideology? And the stated reasons put forth for security concerns, et cetera, actually ideological in nature. The one other thing I'll mention, there was a class action lawsuit under the regarding the cancellation of the MAVNI program. I believe it arose out of Florida. And in initial discovery and initial rulings from the court, it became clear that the government, under the direction of the Trump administration, are implementing these changes ideologically, and they're using claims of security as pretextualism. I believe there's already been one ruling that the denial of the citizenship applications from these individuals, their abrupt discharge and the denial of their applications violated the Administrative Procedure Act, that it was arbitrary and capricious, that there was absolutely no evidence that these increased security concerns were a real thing. So these are questions I would urge the Commission to ask in its regular duties. Thank you.
All right, thank you, Travis. So now we will give the commission members or committee members the opportunity to ask any questions that they may have for any of the speakers or panelists at this time. Does anyone have any questions?
Sure, I have a question.
All right, David.
Mr. Iniguez Lopez, I read the complaint in your Freedom of Information Act case and thought it was very well written. And that was, as you said, filed in September, and then I went on Westlaw to see what was happening in the case and didn't find any other documents in there. What's going on with that case now?
Right, so the litigation was temporarily stayed due to the shutdown.
Okay.
Once the government reopened, it was unstayed, and it is currently pending in federal court. The counsel to different parties are in conversations to see what information the federal attorneys working with USCIS in the different departments can produce so that we don't have to go to litigation and we could receive the documents requested in the original FOIA.
Okay, super. So has the government filed an answer to your complaint yet?
They have, yes.
Okay, it just wasn't on Westlaw. But anyway, so it sounds like they're making some at least belated progress towards cooperating and complying with that request.
Yes, now there's a question of how much cooperation and how much information we're going to be able to receive. It could be that we receive part of it and we have to litigate based on the rest of it, but that is yet to be determined.
Okay, great, thank you.
Thank you all for being here today. I wanted to raise a question that might possibly be commented on by all three of you, but I'll leave that to you individually. Diego and Nicole had both raised the possibility and the concern that there might be either intentional or non-intentional voting rights infringements that are raised by these naturalization backlogs and delays, especially because if I understood you to be saying that the projected timeline for needing to be able to participate in the 2020 presidential election was May of 2018, that time has already passed. So I wondered if each of you could comment on the extent to which we have evidence about the nature of the motivations for that potential voting rights infringement, in particular, along the lines that I think Diego had started to outline for us, the possibility of individuals being in a swing state, which, as many of us know, Colorado does swing back and forth across elections. And so Nicole, as someone who was working on the ground here in Colorado, I don't know if you have thought about that. Travis, I know, had mentioned the possibility of the impact on vets, who I know are in many cases members of racial minorities. Some specifically from the special immigrant programs that you mentioned are Middle Eastern or Muslim, who I know sometimes have come under additional scrutiny for national security as well.
You want to go first?
Sure. So we have contextual indications that this is a intentional effort to reduce access to citizenship and therefore the different benefits and rights that come with it, including the fundamental right to vote, including the backlog, the processing delays, the series of regulatory guidance and practice changes within USCIS. The intentional evidence is what we're seeking in the Freedom of Information Act and subsequent litigation. But it is true that in many different cities, the processing delays are so long that they will not, that many people who have already applied risk not being able to vote. And that has already happened in multiple states. It's going to increasingly happen in March and as the year progresses. So in effect, it is going to infringe on citizens' rights to vote. We are currently seeking the information, which is the basis for those practices.
And I would say that looking back at 2012, 2015, if the commission so chooses to look into the year and a half before election, you will see the spike increase every year because folks realize that it is an important step to take if they want to more fully participate. We also didn't talk about derivatives. So many folks who are parents of young children automatically will receive citizenship if their parents apply before the age of 18, if they are also lawful permanent residents. So many folks are motivated for that as their children are nearing college age or looking for scholarships and opportunities for their higher education. And so that's one element that we can look into as well. According to the New York Times article that is dated February 21st, you can see that the backlog in certain places with a higher demographic shift, Florida, Colorado, Nevada, those months increase when you look at rural areas or more places with lower immigrant populations, they're right under a year. So I would ask the commission to look at the connection between growing demographics and the backlog. The other, I think, part of the conversation that is important, and you mentioned that, Dr. Chen, is that there is a sense from community and from all of the coalition partners within National Partnership for New Americans and the New Americans campaign that USCIS in the past had operated very much as a customer service agency. And those fees that people pay for their naturalization application are a fee for service. people should be met with timely application processing. If you look at, and I don't know how you all could figure out how to look at the language shift, but clearly in 2017, the language around USCIS changed within that website. So there was an intentional effort to switch language around immigrant integration and more toward the vein of assimilation. And so for us, it was one of the initial red flags around intimidation of language and also a culture shift within the agency itself. When they knew that the backlogs were getting too high, or when they knew that an election year was coming, USCIS would then mobilize resources to meet that additional demand and work with service providers, including the thousands of legal service providers across the country, to actually meet that incoming demand and coordinate, the baseline numbers that were going to be coming through. And so while we've seen no additional capacity within USCIS for N400, we've seen an uptick in folks who are really looking at the denaturalization efforts. And so for us, it's quite alarming to see from the outside that folks, instead of reviewing and adjudicating applications, are being funneled over to denaturalization efforts. So we'd like to have inquiry into whether or not there are actual numbers of staffing for each of those departments, and if denaturalization is in fact in an interior memo, where that is living within the agency.
Yeah, I would just add briefly, I think it's pretty easy to connect the dots with regards to what my fellow panelists mentioned and the issue that I raised as well. I mean, on the one hand, we have personnel in the administration who have made public statements with regards to their ideological positions on immigration, immigrants, naturalization. We have the policy changes of USCIS. We have USCIS changing its mission statement. We have the State Department and Departments of Homeland Security and this increased vetting, which allows less folks to be able to come over, including SIV and P2 participants. And then again, the claims are always, increased security. But then we come full circle when we look to the court cases. We look to the citizenship question on the census litigation, in which that's now public, the pretextual ideological claims hiding behind the claims of increased security, in addition to the litigation out of Florida with regards to the cancellation of the MAVNI application and folks being in limbo with regards to their citizenship. So I think, plain as day, we're really collecting evidence that, collectively, this is violating a lot of non-citizen civil rights. And, I hope for increased litigation in this regard.
If I may ask a question, hi. I actually been through the whole citizenship process myself. I got my citizenship in 2013. It was, anyway, according to Pew Research's study, that traditionally less than 50% of eligible green card holders actually apply for citizenship, and mostly because it's a volunteer activity. Many people who are eligible do not find it necessary to apply for citizenship for the additional benefits like voting or serve on a jury. And as you mentioned, Nicole, you see the spike of people, the basic demand for citizenship increased leading up to the 2016 election. So could it be part of the reason for the backlog is because there's an increasing demand, but the USCIS is not equipped with resources, I don't know, personnel, whatever. They do not have enough resources to deal with the increasing demand. And from the processing standpoint, what are the things you think the USCIS can do in terms of having enough resources to meet the increasing demand?
Yeah, I can try to tackle that in two parts. One, in this environment, obviously, we've seen the attacks from the Trump administration for green card holders as well, not only the folks that are unauthorized to be here, but folks who are green card holders. So a minor civil offense can become a deportable offense. And so I think that is increasing folks' desire to go ahead and become citizens. But at the same time, agencies such as Department of Homeland Security will increase personnel and are looking for appropriations on a regular basis to increase personnel in that area, while personnel for USCIS is most likely has not been increased during the course of the Trump administration. And so there's two things happening. One, the community knowledge and anecdotal knowledge that not taking this step will increase your likelihood of deportation for a minor offense. And then at the same time, the backlog is highly discouraging for folks to go ahead and take the step. So there's a little bit of a psychological conundrum happening for community members and also in terms of where the resources are being put. So DHS, as you know, was recently appropriated the $1.3 billion for part of the wall and more DHS agents. Meanwhile, I would like to know what are the appropriations that are allocated for USCIS for a fee-for-service agency within our federal government. So I think both things are happening in conjunction with each other.
I would also add, I don't have the data in front of me, but I'm confident because I've looked at it, that the increase in naturalization applications does not align with the increase in the backlog and the rate of denials. In other words, while there has been an increase, it is not, it's part of reason, it's certainly not even half and half with regards to the discretionary ideological reasons for maintaining the backlog and with regards to just lack of resources. And that's borne out in the numbers, which are public data.
Travis, that's sort of the heart of what at least one of the key things we're trying to find out. So I would urge you you have another month to submit written comments. So I'd urge you to follow up on that and provide the data and your analysis of that issue.
Hi. I'd like to talk about pretext for a second. So I realize that you folks are here testifying before us because at the end of the day, we are going to draft a report and deliver that report to either the executive branch or Congress or somewhere else. How much of the case law takes into account the Trump v. Hawaii case and the deference that is given to the executive branch? Because I assume whatever report we prepare is going to have to take account of that case and the fact that facially neutral policies that go through executive branch processes get a lot of deference in terms of equal protection, maybe Title VI law. Do the cases take into account the Trump v. Hawaii case? Should we take that case into account in drafting our report? Even considering that case, are there reasons why a neutral policy in this context is more pretextual than, for instance, the so-called travel ban? What should this commission do in that regard with respect to legal precedent from the Supreme Court?
So I would urge the commission to inquire on the issue of why there is these huge amounts of backlogs and the processing delays so that we can determine what is the pretext for the facially neutral policies that you're referring to. I think that a commission such as this has some power to get information that USCIS is not being forthcoming with. And that in doing that, they would help us to understand this issue a lot more and the inner workings of USCIS.
I would certainly defer to far better legal minds than my own, but I would say that my understanding is that the Travel Ban 3, Trump v. Hawaii, a lot of the litigation that we mentioned initiated before then, so that's first of all. Second of all, a huge criticism of that opinion, and I think there's going to be subsequent litigation, is that both in the briefing and both at oral argument, to a significant extent, the majority, used this waiver process as evidence of not pure pretextualism. However, with regards to my mention of the Secretary of the Military Services certification of honorable military service as there being no procedure for it, there's a lot of evidence now that there's actually literally no procedure to obtain the waiver. I think the ACLU and other folks are looking at that pretty strongly. And so I don't think that it forecloses it, because my reading of Trump v. Hawaii is not unless you have the biggest smoking gun ever in front of us, we defer. It was that, significant part was we can't put a huge amount of stock in campaign statements prior to taking office, And with this litigation at the lower level, again, with the Mabney litigation, it doesn't get to, the presidential deference. It's, the Defense Department is an agency. You made a decision. You're bound by the Administrative Procedure Act. And my understanding of that litigation, even though it hasn't finally concluded, is that the court essentially said, you don't get to just say national security. You don't get to just say, we are doing this for additional background screenings. We don't have to provide you one scintilla of evidence. I think we know that there is significant deference to the national security establishment and the executive among the courts. It's always been that way. The case law is very strong. But I don't think it's a reasonable legal analysis, or it would be reasonable for this commission or any other body to say that that deference is so high that when there are claims of pretextualism, that governmental entity does not have to provide some kind of solid evidence. And with regards to the travel ban, and with regards to military naturalization cases, and with regards to the citizenship question on the census, we are seeing not only a lack of hard evidence, but actually some significant evidence for pretextualism as well.
I would affirm everything that my colleague Travis alluded to, but I would say, if looking at the big picture, the attacks on lawful immigration and the path forward, and then the intention to build the wall and the continued attacks to the asylee process along the border are certainly coming into the big picture for us in the advocate community around, first we attack obviously unauthorized entry of folks into our country, then we attack the asylee refugee claim process, then we actually, we're looking at, in the big picture, not only the campaign language, but again, the continued attacks on the many ways that people immigrate to our country. And so many studies are underway, including Migration Policy Institute. The main, it seems from us as advocates that it's along the southern border where the attacks to the future flows of immigration continue to be under attack. And I would add, CERC, along with many, NPNA, joined the suit with the state of New York around the citizenship question. And so thereby, intimidation and actually certainly symbols to the community that, like, you do not matter and that your presence in this country does not matter. There are thousands of mixed status families here in Colorado where these kind of attacks to every avenue of migration, of future flows of immigration, of current status, continue to be viewed as continual attacks on Black and brown communities and future flows of immigration to this country.
I'd add briefly one last thing. There is no right to U.S. citizenship for non-citizens under U.S. law. But under U.S. law, non-citizens are entitled to due process rights. Due process rights are a civil right. And while USCIS has a tremendous amount of discretion that they're certainly choosing to exercise to an expedited degree in this modern era, they are bound by law to respect the due process rights of non-citizens. They are not allowed to arbitrarily or for pretextual reasons sit on and deny citizenship applications while claiming another reason for public view. That is against the law. And I hope that this advisory committee advises the U.S. Commission on Civil Rights to that effect.
I can ask a follow-up along these lines, and perhaps some of the immigration attorneys who will be speaking on the next panel could also speak to this. Sure. I wanted to follow up by asking about the constitutional and statutory right that is assigned to non-immigrants who already have green cards to naturalize. And perhaps the immigration attorneys who are on the next panel can speak to this a bit more directly. But my understanding is that unlike discretionary grants of visas short of naturalization, that the right to naturalize is provided for by the Constitution and the Immigration and Nationality Act. So I do have a slightly different understanding of that. And I wanted to highlight the point and ask for your insights into it, because as I understand it, Trump versus Hawaii dealt with immigrants who were seeking entry to the United States and explicitly did not deal with individuals who had green cards, who otherwise are kept outside of that travel ban. Bringing us back to the jurisdiction of our body and the body that we are advising, the U.S. Commission on Civil Rights, we have particular jurisdiction over voting rights, which is some of why you'll keep hearing us ask about it throughout the day. We also have specific jurisdiction over federally protected groups on the basis of civil rights. And so I did ask before, but just wanted to follow up and ask a bit more directly about the extent to which there is an intentional or even a disparate impact on racial groups, national origin groups, religious groups specifically, because those are all federally protected groups over which we would have particular concern. So, I mean, a simpler way of asking that question is, do you know what numbers or percentages of the non-citizens that your community groups work with are members of racial groups, racial, religious, or national origin minority groups?
I would, as Colorado's Latino immigrant population continues to hedge toward 24%, 85% of all of our workshop participants and petitioners are from the origin of Mexico and or Central America. So we do see that there is obviously a connection to the demographic of each state and also the folks that are seeking naturalization. I know from the Muslim community that many folks are very skeptical of the double scrutiny in this community, so of the current situation. And so we have many folks who really struggle with turnout in those communities to be able to get folks to naturalization workshops and to see the process through. There's almost a lot of sense that we'll wait for this administration change and then we'll go ahead and apply in a different environment. So anecdotally, we have data on Muslim Americans, but clearly the Latino voting bloc and the potential of Latino voting bloc is cited within groups like NPNA. We can talk about Unidos US, who has data on potential voting bloc of new Americans in states like California, Nevada, Colorado. And we surely see the connection between demographics and suppression of votes. And then I would talk again about the connection to the Census 2020, right? If we have intimidated community members from filling out the census, and especially those of mixed status families, many folks will be uncounted. And so we are very concerned that overall this thread and connection is going to thereby limit the accurate count and participation of folks in the census, and therefore Senate districts, congressional districts, and state infrastructure allocations based on intimidation tactics from this administration.
And I would echo everything that Nicole mentioned and add that the proposed regulations and effective policy guidance are also going to have discriminatory, disparate impact on applicants. So the changes to the N400 application, we believe are going to have, once implemented, impacts on immigrants from Latin America, from Africa, from the Middle East, and the already effective policy guidance on the N648 will reduce access to citizenship for applicants with disability and therefore disparately impact those applicants.
Is there evidence that applicants with lighter skin tones or other demographics besides, I don't know, I'll just leave it there. Is there evidence that lighter skin toned applicants are being fast tracked or being given special privileges over other immigrants with darker skin tones to establish some sort of pretext in the disparate impact world?
Well, with regards to non-citizen veterans, approximately the 100,000 that exist right now, what I can say, a number of those who are removed may have had, pending citizenship applications or citizenship applications that timed out or never submitted them. And I don't believe the data exists, but it certainly calls for study. So of those 100,000, how many committed crimes that rendered them removable from the United States? Because among the deported veteran community, among the many hundreds that are documented, overwhelmingly Latino and Latina. So, I think that is something that certainly calls for study. Is there statistically within that, are we seeing the denial or the removal of more veterans of Hispanic origin than of other ethnicities?
Thank you for that. What I'm trying to determine is if the response to all of the measures that you referenced today is, well, the current administration is just hostile to immigrants more generally, and that's a bad policy decision, then that's a little bit of a different position than there is discrimination on the basis of race occurring. So that's why I was asking you about pretext before. Is there something to establish that it's not just a general anti-immigrant policy, but is specific to certain types of applicants?
I think the evidence there is that if you look at the top 10 countries, or the countries that have people who are being naturalized, who have naturalized, what you're going to see are people of color. And in all of the barriers to citizenship, what you're seeing is that the people who are not being processed, who are not being naturalized, they do have a darker skin color.
And I think you can also look at you start with the Trump administration and individuals like Stephen Miller, and you start with the Trump administration's public statement, cabinet's public statements on immigrants, their feeling on immigrants, immigration, their goals. And then individuals like Stephanie Miller at the Pentagon, who is a Trump administration DOD appointee who implemented these policies. And then you continue further into the litigation where the courts are saying there's no good reason for this was pretextual. And that's just one example. So to answer your question, I don't think there's nearly as many smoking guns as we would like, but I think more are coming out with regards to litigation every day.
Do any other committee members have any further questions?
Yeah, I had one question for Nicole. You mentioned an incident in which a daughter and her father, a daughter went to apply for naturalization and her father had a green card and the father ended up getting deported. Mm-hmm. What was the basis for the father's deportation?
I believe there was a minor infraction from 10 years prior, or 10, 11 years before, but it was a minor offense. And so they were in the USCIS office and had said, come, we want to talk about your application. Instead of going through DHS, he is a green card holder. They could have actually called him through DHS and issued a right to appear in immigration court, and he could have studied himself with an immigration attorney, have access to full process. Instead was lured into a USCIS office where ICE was waiting for him. So
So was he deported?
he was deported.
Like that, they grabbed him and took him out of the country immediately?
Yep, he was
Without a
deported
hearing?
and held at GEO. So he did have immigration proceedings, and I think that at the end of the day, not having access to due process and going through the channels with immigration law was really detrimental to his case. And so there wasn't adequate time and preparation for him to be able to prepare his stay, and was deported within, I believe, 1.5 months. So in a period of 6 weeks, this individual was deported. And there are other folks who have called us who have said, would you please accompany me to my appointment? And my understanding is that, in particular, the elder community is very concerned about attending these appointments without accompaniment, and so have asked my staff many times from workshops or our volunteers to attend with them. Though they can take the test in their native language, they're just, the level of intimidation for community in general is there because of the few stories that get lifted up in Spanish media where incidents like this have happened.
Sure. Just to follow up on the one case.
Yes.
The green card was issued erroneously because they missed his prior conviction?
Yes.
Or, okay, and then he was detained immediately when he went to the office for his
USCIS.
for his daughter's naturalization application, and he was detained for a period of approximately 6 weeks, and at the end of that, had the and then there was a immigration hearing where he had the opportunity. He was obviously it's harder to organize a defense when you're detained.
Right.
But he had the opportunity to have an attorney if he wanted and to present witnesses and all that, although I assume it was a fairly simple factual case since the
I
conviction
don't
was.
have all the details of
Okay.
his proceedings after that occurred, but
Okay.
obviously not having access to due process and not having the opportunity to appear in immigration court and process stay was a part of why the case ended the way that it did. Many folks that end up in a similar situation like this, or if they know they're heading to immigration court, have the opportunity to put detainers down with immigration defense attorneys. And so in this case, this individual did not have access to issuing, detainer with an immigration attorney and get the proper support that he needed. So it's just one scenario of where USCIS and ICE collaborating was a clear strategy to remove this individual, as opposed to saying ICE would actually, issue a notice to appear for this individual, as opposed to apprehending him within a USCIS context.
Did he ever come before a judge of any kind?
I believe he did go through an immigration judge, yes.
Okay, but the fact of his conviction was obviously dispositive in that case.
I can't speak to
Okay.
the rest of the case, but the part where we were involved was around the USCIS.
And do you recall what the conviction was for?
I don't.
Okay, thank you.
Not knowing the particulars of the case, I'd just like to add, first of all, the vast majority of immigrants are not represented by counsel. They have no right to counsel. They can't afford it. The other is that there's an increased conscious effort on the part of DHS and ICE to pressure immigrants to consent to expedited removal. Essentially, an ICE officer will say, well, do you want to sit in immigration detention for 6 months while you look for an attorney, or while your appeal goes through if there was a denial, or do you want us to get you the hell out of here? And a lot of non-citizens will say, well, even if they have an attorney, if they said I have a very little chance, I'm going to consent to expedite, and that can really fast track the process. That's something they've been using a lot increasingly.
Okay, great, thank you.
To follow up on that, I've heard stories, and these are just media accounts, of children, very young children, representing themselves, 3 or 4-year-old children without attorneys. Can any of you speak to that, and whether there's some sort of due process issue in your mind on that issue? That seems like an unlikely situation for a 3 or 4-year-old to be able to represent themselves in immigration court.
I'll defer to others who might know. My understanding is that the ACLU initiated some litigation with regards to a federal judge in Texas being on record as saying that a 4-year-old is perfectly capable of understanding the proceedings in front of them. So I think there was some litigation around that, but I don't have specific knowledge of it.
We, obviously a lot of those cases were around the family separation at the border, Tornillo, Texas. So we refer to children in need of defense, or kinds that really provide free legal access for children. My understanding is that does not happen in Colorado, that we actually have many organizations, including one of my members, Rocky Mountain Immigrant Advocacy Network, that has a children's accompaniment program and also a detention representation program to make sure everybody in detention and or proceedings at least has access to know their rights.
I have one more question for Diego. In your presentation, you mentioned that in the past, USCIS was able to reduce the backlog dramatically, at least in history once before. What did they do exactly?
Increased additional resources.
Have more officers and
More officials, they allocated resources to where the backlogs were, the particular applications, and through a series of measures were able to reduce the backlog.
To follow up on that, could you, since we're not experts on DHS internal procedures, to what degree does DHS have discretion to, under current law, to move officers around, with both from one task into naturalization processing or vice versa?
Well, I believe USCIS has a good amount of discretion on where they allocate resources.
I'd like to see the numbers of how they allocate staff to each department. I don't think that data, without pulling a FOIA, is readily available to the general public.
Okay, thank you.
Do you want to remind people?
Oh, I'm sorry, I was just going to say, I can't remember the specific name or acronym, but essentially with regards to ICE, there are two divisions. There's ERO, Enforcement and Removal Operations, which are the ICE that we all know, but then there's a separate investigatory body. Again, they have tremendous discretions on not only how many folks are employed, but also what they do. I mean, that's a whole separate issue, but they have a tremendous amount of enforcement discretion, and that's another serious issue with regards to how they're choosing to use that and whether it's actually for reasons of community safety or to just get the most non-citizens that they can out of the
So is it your understanding that an ICE employee can be put on the removal, tasked with doing removals, or can be tasked with processing naturalization applications, and that's a matter of administrative discretion?
So those that process naturalization applications belong to USCIS, separate from ICE
Okay.
under Department of Homeland Security. And I'm not sure with regards to employees of whether they can apply to transfer, what rights they have. That I do not know.
But in any case, it's not something where an administrator can just move them from one job to another.
Not in my understanding.
Okay.
Not in my understanding, but I can't say that definitively.
Okay, thank you.
I would ask the commission to investigate the denaturalization task force that has been talked about often. It has a name, and I can't quite recall the name of it, but it was Operation something that was clearly an effort to go through records as old as 20 years to look for people who were in violation of any infraction, or look for especially people coming from war-torn countries or situations of genocide, to actually find a measure to remove them. So I can't recall what the name of that denaturalization task force was, but certainly allocating staff to that task force as opposed to processing and adjudicating is a concern of ours.
I just add one last thing. I would urge the commission. Secretary Mattis, when he was a Secretary of Defense, stated that there would be no more removal of honorably discharged military veterans. In 2018, the Defense Department said all service members with an honorable discharge are protected from deportation. This is both a factual and a legal lie. It's still happening. One of the highest profile cases was out of Chicago, where a veteran that was injured in Afghanistan was placed into removal proceedings for drug charges. So, that's a civil rights issue, and I would urge the commission to look at that, the advisory committee to look at that.
Well, and thank you, and it will help us when you can submit written reports, because just as citizen volunteers, as we've learned when we submit a draft report to the U.S. Commission, they are very persnickety about wanting detailed footnotes and citations. So the more you can help us with that, the better.
I was hoping, as we are getting near the end of this session, if you can help us think about what kinds of recommendations we can make. So in addition to the findings that all of these additional facts will help us with, what kinds of recommendations do you think we can make to the various federal bodies, the different branches of government? In particular, I heard outlined in some of the strategies that your groups are involved in that there is a lot of investment in increasing congressional oversight, and recently with some promising follow-up to that with the announcement of the hearing and the letters that have been sent to the director of USCIS. However, one of the things we have not spent significant time talking about is the unusual fee structure at the USCIS, where I believe it's 90% or more of the budget doesn't come from congressional appropriations, but instead comes from the user fees. So I am curious to know, specifically on congressional oversight, if you have any concerns about a potential lack of accountability between the USCIS and Congress, and to the extent that seems like a limitation, what other channels you think we could pursue in asking different bodies to pay attention to this issue.
And if I could just follow up on Professor Chen's important comment. I think you've raised a number of important issues on a variety of topics, but we are at the moment focused on the naturalization backlog. And so the other things you've raised are certainly important, and I'm glad you've helped increase public awareness of them. But in terms of what recommendations we might offer, we'd want to focus on that particular issue.
Just with regards to your question, I mean, an example I would use, one recommendation would be that with regards to USCIS's discretion, when I was working at a criminal immigration firm in Denver, I was working on a naturalization application. in which USCIS, unlike in previous eras, is deciding to use its discretion. And keep in mind, every time it requests additional evidence or issues a notice of intent to deny, that contributes to the backlog. The longer each application takes, contributes to the backlog. So with regards to their discretion here, I think I would urge the committee to recommend that discretion be used differently. With regards to this individual, you have a case where someone's been here a very long time as a green card holder, and you have a criminal conviction which does not bar them from citizenship, and in fact, which is pretty minor, but which they choose to use as an example of failing the good moral character requirement. If you'll talk to any immigration practitioner, and the folks coming up next can speak to this with serious specificity, it's happening in a way now, same with DACA denials for driving while ability impaired, that it never happened before. And so the question becomes, well, before, was everybody doing it wrong? Was USCIS and DHS abusing their discretion and allowing dangerous folks who really shouldn't be here to be here? Or are there really serious ideological reasons dressed up in security reasons, dressed up as legal reasons that are kind of taking over nowadays? So that would be one recommendation I would make.
Thank you.
I would say the budget office that oversees USCIS is certainly a place for increased inquiry. What are the appropriations that go to USCIS, to the Naturalization Task Force, as opposed to other efforts within that department? I would also ask to see what is the new framework that USCIS has issued internally, the memorandum that are internal versus from the previous administration. How has the language changed? What can you analyze from the change of culture and internal process that would be different between two administrations? And then I would also ask that folks really look at the connection between civil rights and lack of access to due process. So just what you're doing seems to be on the right path to continue this conversation and get to the heart of the matter on the potential for voter suppression by way of the naturalization backlog.
I would request that the committee and the larger commission inquire into some of the questions that we asked in the FOIA, including communications between the White House and USCIS. As Nicole mentioned, budget and allocation of resources to different facilities, the extent of complaints that USCIS is receiving because of discrimination, abuse, or inappropriate treatment, and that in getting any response from USCIS to really scrutinize their plan, their metrics for success, their timeline, because when we originally started this campaign, they didn't even acknowledge that the backlog was an issue. They said it was not a backlog. And in subsequent times, they have kind of tailored their language a bit and said that they have received a lot of applications, even though applications have gone down, and that they're working through it. But we're seeing that that's not the case, and that applications still remain, processing delays are increasing, and there is no plan. And we suspect that we have a lot of evidence that there is no political will to do that. So to the extent that this committee and the larger commission could pressure the agency to show plans that are really going to have follow-through and that are going to show results and that have some basis in reality in previous practices that have worked, to pressure the agency to do that.
Okay, so we've come to the end of our time at this point and would like to tell you all thank you for coming today and sharing your viewpoints. We really appreciate it. I do encourage you all to submit statements. We can provide that information to you on how to do that because it is very important that we reference the points that you've made today, and it would be good to have that in writing as well as a refresher for all of us as we move forward in preparing the report. So thank you again, and we'll go ahead and start moving with our second panel at this time. Thank you. All right, we'll begin our panel 2 presentation. We have John Eastman, Professor of Law and Community Service from Chapman University Fowler School of Law. Here, Jennifer Cain-Rios, Immigration Attorney from Cain-Rios Immigration LLC, and Robert Pruis, Professor of Political Science from Metropolitan State University of Denver. So we'll go ahead and start with Mr. Eastman. Each of you will have 15 minutes to speak, and then after that point, the committee members will each have an opportunity to ask you questions. Thank you.
Thank you, Senator Hart and members of the committee. It's like old home week for me. I was at the U.S. Commission on Civil Rights for several years, and one of my tasks when I was there as the head of Congressional and Public Affairs was to help nominate people to the advisory committees around the country. So it's nice to see things are still in place. My other hat, I'm a senior fellow at the Claremont Institute, and I should give the necessary disclaimer that my two professional affiliations may not necessarily agree with the things I'm saying here. These are my words and not theirs. I was going to give you some discussion about some of the legal issues and the due process concerns, but as I was looking at the materials that had been provided to you, I thought it more important to put my political science hat on, and because some of these materials are just blatantly erroneous, and I think I've long been in favor of trying to streamline the process and make it work better, but I think it's extremely important to have the underlying data correct as we're looking at these things. So, for example, the backlog that we now have the highest backlog that we've had ever, I think. But the backlog over the last couple of years has actually increased at a slower rate than it did during the 8 years of the prior administration. The number of new naturalized citizens was the highest this past year than it has been since 2013, and higher than all but 2 of the full fiscal years under President Obama. And those were significantly lower than the last fiscal year under President Bush. So one of the things that I think would be particularly useful for this advisory committee to do is to kind of help us back away from the partisanness of some of the data and try and look at the long-term trends. I think any recommendations that come out of the committee would be better received by both sides of the political spectrum in Congress as they're looking at these things. Some of the other data, one of the reports that was given to me was a report by the Cato Institute on the increasing size of the forms. I've not looked at every one of the 15 forms yet. I've gotten through about half of them. But here there are some stunning errors again. Things that were attributed to the current president. The forms actually changed in December of 2016, weeks before he took office. And in my written testimony, I've got specifics about that. But just for a couple examples, the 10-page version of Form I-914, which is the application for T non-immigrant status, it replaced the prior 9-page form. It's facially dated February 27th, 2017. But web archives are wonderful things. It was actually uploaded to U.S. Citizenship and Immigration Services website on December 28, 2016, 3 weeks before President Trump took office. The 15-page form N-600, which was the application for Certificate of Citizenship, increased over the prior 9-page form. That was uploaded to the website December 22nd, 2016. And then the 2-page I-265 form, application for employment authority, is actually even dated before the change of administration, January 17th, 2017. And yet in the Cato study, all of those things are attributed to the President Trump administration. And that's assuming you can even attribute to him things that are going on in the bureaucracy and that, that take a longer lead time to get than just a turnaround. So I think it's very important to kind of step back from those rather hyperbolic claims and actually look at the underlying data correctly. Even for those that were subsequently changed after the Trump administration came into office, though, there are some pretty egregious errors in the claims made about them. Most of the addition in length in a good many of the forms is the form providing more space to provide the answers for exactly the same question. The bottom of the prior forms would say if you run out of space, just attach additional papers, and the newer form, the longer form, has more lines of space to provide the answer, so it's less necessary that you may need to attach additional forms. There is some interesting stuff, though, that I've not quite gotten to the bottom to yet, but I think it would be useful to look at. There's some additional information about employment history, about parental status, both for the petitioner and the beneficiary on such things as the forms for bringing in close relatives. it would be nice to trace whether some of those things are statutorily driven in some of the ongoing changes to the statutes, or whether they had always been in the statute and the information was just not requested before, and people realize we ought to be asking about that because it's part of the statutory criteria. And you know, that kind of leads to another overarching concern about the data and some of the reports I saw. Most of them, you know, compare a relatively short period of time. And when you're looking at trends, to look at the first 2 years of one administration and the last 2 or 3 years of another, you can't tell whether there was a decline in enforcement or more of a rubber stamp from the prior administration, that the new one is returning to a more a comprehensive assessment as the statute requires. Looking longer trends, looking back to the 1980s, 1990s after the 95 Act into the 2000s would give you a much better sense of what's going on. It's a little hard to take too narrow a slice out of that. You know, another example, the 10-page version of the I-914 form actually requests less information than the 9-page prior form. There was a question on the prior form about receipt of public assistance that was dropped, but the pre-typed certification language, there are additional requirements in what you're certifying, I suspect driven by a court decision someplace, that you have to give notice that by filling this form, somebody might be asked to come in and swear under oath to verify the information. That's now part of the certification when you sign it. That takes up an extra quarter of a page, and that's the reason the thing kicked over to the extra page. So attributing that to some malevolent purpose to increase the form size to make it harder for people to get through the process, I think is just inaccurate. Now, like I said, some of the information is new. And, you know, and I think it's important to try and trace back to either a statute or a regulation why this additional information is there, and see if there's reason for it, statutorily driven, that the USCIS recognized they needed to be asking about this information. On the I-130 form, for example, there's information related to the nature of the parent-child relationship rather than just the checkbox, is this the basis of your application? Is the relationship, what was the marital status of the parents? Is it a step parent or stepchild situation? Is it an adopted situation? None of that information had been requested on the prior form, but it is here. A lot of the space of the additional information on the forms is just due to adding more contact information request. Not just your address, but your mailing address, your prior address information, and your work address information. I suspect a lot of that is designed to be able to locate people if there's a request for additional information on what is a relatively transient population. If we have more contact information, maybe we can reach out to them and get a quick answer and process the information, the forms more quickly, rather than having them sit in idle status because we've got an outdated address. There's information on the petitioner's legal permanent resident status. That's only requested if the petitioner is not a citizen. But here again, that wasn't asked on the prior form, but I suspect, and I've not traced this back yet, but I suspect it's because either a statutory change allowing for these applications to be submitted by LPRs rather than merely citizens, and of course then the added information is now required by the statute, but it's to broaden the applicant pool for the beneficiaries rather than circumscribe it. And so I think those things are extremely important to keep in mind as we're trying to make recommendations that get us away from this president is being more restrictive than that president or vice versa, what have you. What's wrong with the system that's continually increased the backlog every year? Is it people dragging their feet deliberately? Is it simply a lack of resources? If it's a lack of resources, is that tied to we're asking too much information? And how much of that is driven by regulatory guidance versus statutory mandates? If we connect it to statutory mandates and the recommendation is that some of that information is just not necessary, then that recommendation to Congress would be, why don't you remove that criteria, eligibility criteria, remove the statutory mandates? That will help streamline the process. If instead Congress insists that that's an important piece of information we need to determine eligibility for these various things, then Congress needs to know what the consequences of that mandate are so they can adequately staff up the organization that's tasked with doing these. And I think recommendations on those lines, connecting those kind of dots, rather than the pointing of the fingers at one administration or another, would be much more useful and much more likely to get implemented out of what's a pretty hyper-partisan Congress these days. Thanks very much.
Thank you, Mr. Eastman. Ms. Quinrios, your time is ready. Go ahead and start.
Thank you. So I just want to give you a little bit of background about myself. I am an immigration attorney. I have been practicing immigration law since 2001. I have been a sole practitioner, meaning I have my own office. I don't work with other attorneys that work for me, or I work for them for the past 10 years. Between 2004 and 2014, I was part of the committee that liaises between our professional organization, the Colorado chapter of the American Immigration Lawyers Association, and USCIS office in Denver. So I have not been in that liaison position for several years, but I have been, but I can remember those 10 years of working closely with my fellow immigration attorneys and the Denver field office and all of the changes that have happened over that period of time. And this has been a little bit of a walk down memory lane as much as I can in the limited amount of time that I have here. So I've also, in the course of preparing to speak with you, several things have kind of been light bulb moments for me. So looking at the fact that the largest reform for naturalization in recent history occurred in 1990, that basically took away, well, that shifted primary jurisdiction from the federal district courts to the agency, was passed in 1990, the Immigrant Act of 1990. It was meant to improve backlog times. So all the way back to 1990, there have been cycles of times that it has been difficult for people to complete the naturalization process in what was at any given time for their contemporaries considered a reasonable amount of time. So, and I also remember times when I was practicing that naturalization applications were processed in 90 days, 120 days, meaning from the time that you filed to the time of the first interview, it was only 3 months. Now, I think it's important to get a little bit into the minutia of the actual naturalization process and procedures so that you can understand where I kind of wonder what the published processing times really mean these days. So a client files for naturalization. Within about 2 to 3 weeks, they get a receipt. 2 to 3 weeks later, they get an appointment to go and get biometrics taken, meaning their fingerprints and a digital photo is taken. And then they wait. So for me, that waiting time is my biggest concern, because that is a period of time that I, or the applicant who doesn't have an attorney, has the least amount of control over what will happen next. And then when the first interview is scheduled, certain regulatory and procedural timeframes come into play. So once the first interview is scheduled, if during the interview the examination officer decides that more information is required, they'll issue a request for evidence and usually require a response within 30 days. And primarily, that shortened response time, because usually when you talk about other types of applications and requests for evidence, the normal regulatory period is 87 days, or essentially 3 months. And then, if it's necessary, a second interview is scheduled. And we can talk about different scenarios where that first interview and second interview might be particularly important for applicants. But I'm just going to keep going over the broad timelines. So from the date of the interview, you start counting 120 days. after 120 days, the Immigration Service should adjudicate the application for naturalization. That's in the regulations. If they don't adjudicate the application within 180 days from the date of the interview, then federal court jurisdiction opens up under what would be INA 336 or 8 USC 1447B. And so I think that's important to understand, that in order for us to really get a handle on what backlog times really mean, what do we do if months and months pass between the time that someone gets their biometrics done and the time that they're scheduled for their first interview? There's nothing in the regulations, nothing in the immigration law itself that allows for accountability or oversight, other than what would be mandamus review. So mandamus review is something that I can provide more information in my written comments, but essentially it is going to district court to show the court that the agency has a duty to perform certain actions and that they have not done so, and the time intervening is unreasonable, and that there is harm to the applicant because of that delay. And so let me talk a little bit about a couple issues that I have seen in my own practice over the years, and in my particular experience, as well as the experience of my colleagues who were kind enough to complete a survey about their experiences with naturalization delays. And I'll speak a little bit more about the questions that we asked and the responses that we received. One of the things that I've noticed is that people's ability to show their, that they are able to understand and communicate in English is more difficult than it used to be. And let me read you just a little bit about what the law itself says, and we'll read you a little bit what the regulations say, and then we'll talk a little bit about how the English literacy and civics test work in practice. So the statute says that no one may be naturalized unless they can demonstrate an understanding of the English language, including an ability to read, write, and speak words in ordinary usage in the English language, provided that the requirements of this paragraph, and this is the statute written by Congress, that the requirements of this paragraph relating to read and write shall be met if the applicant can read or write simple words and phrases to the end that a reasonable test of his literacy shall be made, and that no extraordinary or unreasonable conditions shall be imposed upon the applicant. And below that is a demonstration of someone's knowledge of history and civics. So a knowledge and understanding of the fundamentals of the history, and I'm going to add it here just for grammatical sake, and the fundamentals of the principles and form of government of the United States. So the statute includes the description of a level of English and education that, if you compare what that expectation at least means to me in plain English to the language that appears on the 20-page naturalization form, there is a potential for discrepancy in the experience that happens during the actual interview. And just to give you a little bit more background, if you are unable to show that you can speak English, and you don't think that you'll be able to pass, but you wait long enough, so you're a permanent resident for 15 years and are 55 years of age or older, or you've waited for 20 years as a permanent resident and are 50 years of age or older, you are exempt from the English language requirement and can go to the interview and complete the interview with the help of an interpreter. But in addition to that, so there are the exceptions, and those appear in Section 312 again. And there is additional consideration for people who are over the age of 65 and have been permanent residents for 15 years. There is a separate exemption completely, for people who can demonstrate that due to a medical disability, medical or psychological disability that they've had for more than 12 months, are unable to either complete the process of naturalization in the English language and pass the English test, or demonstrate their fundamental knowledge, essentially learn the issues of history and the government of the United States. Now, the knowledge that's required to pass the civics and history test has to do with studying 100 questions. And those questions are available for people to study in English as well as in their native language if they are in the process of learning English as a second language. And during the interview, usually the officer will first put somebody under oath and then complete the civics exam and history exam first to kind of get everybody past that hurdle so that they can focus on the rest of the examination, because everybody's nervous. So if you get 6 out of 10 correct regarding the questions that you've studied, the 100 questions for history and civics, you pass, okay? Then you're asked to read a simple sentence in English and write a simple sentence in English. Now, since the test was revamped several years ago, the vocabulary that's expected of the reading a simple sentence and writing a simple sentence is tied to the things that people have studied regarding civics and history. So, you know, there may be questions or the requirement to write or read a simple sentence that has to do with just daily activities, but oftentimes it includes language related to history or civics that the person had studied from the 100 questions. And then that's the information that the regulations refer to as being available on the USCIS website. Beyond that, people's experience who are English language learners at naturalization interviews is that the expectation is that they're able to understand, meaning that they're able to listen to, process and respond to questions on the naturalization form. Most of that information for the first several pages is their own personal data. And oftentimes that's, you know, something that is absolutely, they're prepared and ready for that. Many people are not prepared, however, to deal with the issues that continue for several pages in the form of yes and no questions with very legalistic terminology that is oftentimes not necessarily paraphrased to a degree that someone who is an English language learner may feel comfortable with, especially if they're nervous. So that additional burden of having to complete the process of naturalization by answering all the legal questions in their case, the regulations actually permit the use of an interpreter after someone has demonstrated their ability to understand English, and that an interpreter may be used when the officer believes that either the record would be incomplete or there would be contradictions in the record if the person had to continue in English. My experience is that that is oftentimes something that is not readily understood and is difficult to request and proceed with when you, definitely if you're pro se, if you don't have an attorney, but it's even something that is a challenge proceeding. So so getting back to the RFE timelines, the request for evidence timelines, if you go to the first interview and the person passes the literacy test, meaning that they can read and write in English based on those 2 sentences, and that they are able to get 6 out of 10 correct, the boxes get checked. But what I've seen more recently is that that is not enough to demonstrate understanding of English. So, and that the person is held over for a second interview. The second interview should be conducted, this is under the regulations, within 90 days. Oftentimes, these days, the second interview is conducted within about 60 days. Many people don't know that in the regulations, people are allowed to ask for more time. In the context of asking for more time, basically someone has to do it in writing. So they have to know that they can do it. They have to do it in writing. And in the course of requesting more time to be prepared for demonstrating the English language requirement, that they are waiving access to federal court jurisdiction within 120 days of the first interview, and that basically the 120 days jurisdictional question for federal court review bounces down to 120 days after the second interview. And so our experience as an immigration bar is that we have seen some applications being processed faster than the published processing times. But we've also seen applications that are published, we've also seen applications that take longer, okay? So when we asked our bar, have you experienced the processing times to be within that window of 11 and a half to 17 and a half months? Many people said yes, but you know what, that's a really, really long time. And when the people said no, we had a couple answers that's outside, so longer than normal processing times, 23 months. Several came back with 8 months, 4 to 8 months. So in my experience, I had someone who filed for naturalization last year and was scheduled for her first interview at 3 months. We went to the interview and were told that the interview is descheduled. And the reason why is because the A file, the paper file, did not get to Denver. So let's back up a minute. Where is that A file, right? So when somebody files a petition for naturalization, it goes to a lockbox in Phoenix. Phoenix mails it to the National Benefits Center, which is in Missouri. And most of that processing time between biometrics and interview happens at the service center. So should we really be looking at processing times broken down, especially to focus on that time between biometrics, which is pretty, reliable. The receipt is pretty reliable, the biometrics time is pretty reliable, but that processing before the interview is something where USCIS should be held more accountable. And in order to hold them accountable, we need information about what those true processing times are before the interview. Because the other processing times are governed by the time it takes to respond to an RFE, the time it takes to schedule another interview, and those things are reflected in the regulations. Do they always follow the regulations? Maybe not. But in the end, what we're talking about really is the black hole of why it takes so long for somebody to get that first interview. Because after that, certain regulatory oversight comes into play. And so how long did it take between the time that we were descheduled? It took another 8 months until that second interview was scheduled, and we followed up. So these days, the only way we can follow up is by sending a letter in the mail. So attorneys no longer have access to communicate with the district office. We no longer have an email. We used to have an email. We no longer have a fax number that we can use, and we don't have phone numbers. So we have been instructed that the way to communicate is through the national customer service modes, which is the 1-800 number, which anyone who's used it, whether pro se or for attorneys, takes a tremendous amount of time, and you don't get the information you need. Okay, and they won't respond to delays unless things are outside the normal processing times. So in other words, if you file something and it's not yet to the 17.5-month mark, technically all the agency has to do is tell you that it's not it has not reached or passed normal processing times. We have the same problem when we try to go to the congressional offices to ask for help. The congressional offices want to help. We can show them that we've done all of these things. We've sent inquiries, follow-up letters, but the way procedures are, if it's not outside normal processing times, no one is obligated to do anything, or at least that's what they think. So I'm thinking that maybe working really, really hard to get a breakdown of processing times and what they really mean would be much more helpful. And I think it might help as well to understand the variability in processing times. So, for example, over the past couple years, I looked at several of my naturalization cases and looked at the receipts and the interviews and how long it took to actually get to oath. So I had these two lovely religious sisters from Mexico, and in 2015 and 2016, it took us 9 months from filing to oath. In 2016, I had one lady who was scheduled for her interview in 3 months. She was a little shocked. She was a little nervous. She thought she had a little bit more time to study and practice her English, but she did all right. We had RFEs after that for additional documentation about her compliance with taxes, even though we submitted things showing that she was compliant in paying the IRS. They wanted specific documents, which are really hard to get. So especially the IRS is willing to give you 3 years, and you have to wait a while. So to the point that we had to respond within 30 days without all of the information because the agency didn't have the information available yet. So we had to supplement our response. So knowing a little bit more about what goes on at the service centers and what goes on between the filing, the biometrics, and the interview, I think would be much more helpful when it comes to published processing times than whatever it is that the processing times that are currently published are telling us. Okay? And when it comes to knowing where the money is spent, so as people have mentioned before and is in the reports and all of that, USCIS budget is, the great majority of it is paid by fees, by applicant fees. One of the things that are still trying to figure out, because in the past, our liaison committee, the attorneys who work with the Denver field office, would have access to know who the officers are. If anybody's new, every quarter or so we get a new list of people and we know who's there and who's new and who moved around. We don't have that anymore. So it's hard for us to know why certain officers are taking longer. And it's hard to know what to expect going forward. We know anecdotally that new officers are coming online at USCIS. Will that mean additional delays after the interviews as the new officers are learning the ropes? Are they new officers, meaning right out of training, or are they new officers from being reassigned from other offices. A lot of that information is helpful for attorneys to be able to know how much we need to prepare when we go into an interview, how much we need to brief something or bring copies of policy memos or the regulations, or really review in great detail the policy memo, for example.
Ms. Kane-Rios, we're over the 15 minutes, so if you could just wrap it up. Thank you.
Absolutely. So the one other thing I wanted to mention is what we know about the staffing in Denver is that several of the adjudicating officers are going to be moving into an office called FDNS, or Fraud Detection and National Security positions, which are within the USCIS, the same agency, but are not going to be directly adjudicating and doing interviews with applicants. Rather, they'll be doing additional background investigations. Thank you.
Great, thank you so much. And we'll continue on to our next speaker, Robert Pruis.
Preuss, yeah. Thank you for allowing me to provide comments on this important topic. I'm a professor of political science at Metropolitan State University of Denver, and I hold a PhD in political science from this institution, the University of Colorado at Boulder. My area of expertise is racial and ethnic politics and democracy, and I've published peer-reviewed research broadly on that topic, as well as research specifically focusing on Latinos and immigration politics here in Colorado. Considering these areas of interest and expertise, my comments will address the backlog in naturalization application processing in Colorado and its effects and potential effects on the ability of immigrants awaiting completion of their naturalization applications to participate in and exert influence on the electoral process in Colorado. Immigrants eligible for citizenship face a variety of social, economic, and emotional issues as they await completion of the naturalization application process. Of concern to me is the constraints this backlog imposes on their potential ability to participate in the electoral process. Fundamental to the rights of citizenship in a democracy such as our own is the ability to express one's political preferences by casting a vote. Backlogs in naturalization prevent otherwise eligible citizens from exercising their right to vote during the time spent on the backlog, not due to their qualifications, but due to the lack of an efficient and effective administrative process. This is particularly important as backlogs increase in size and reach processing times that extend beyond future elections. In light of this, several important elements of Colorado's naturalization backlog merit consideration. Of particular interest is the potential for the backlog to constrain potential voters in Colorado from exercising their right to vote and examining the associated political consequences. The combination of these two elements provide a basis for evaluating the relatively straightforward question of the magnitude of the backlog's effect on voting rights, as well as considering if there is any evidence of intent. The following discussion is informed by data presented in a report that I have authored, some of which the slides you have in your possession you can follow around. I won't point those out specifically. But the report, the political participation of immigrants in the naturalization backlog in Colorado, which was produced in conjunction with the Golda Meir Center at MSU Denver. It'll be available and I will upload it in our supplemental materials. The most recent data available from the United States Citizenship and Immigration Services reports 9,995 pending applications as of October 1, 2018, or the third quarter of fiscal year 2018. In Colorado's immigration centers. This number is down from a four-year peak of 10,482 in the previous quarter, and this equates to an estimated range of an 11.5 month median processing time to a 17.5 months to complete 93% of the applications for those filing in Colorado as of September 2018. The number of pending cases increased dramatically from August 2016 to March of 2017, rising from 5,652 to 9,241, or a 63% increase. From another perspective, with data dating back to the fourth quarter of fiscal year 2013, the average quarterly number of pending cases increased from 5,281 during that period under the Obama administration to 9,768 under the current Trump administration. This 84.9% increase compares to a 3.9% increase in the average number of new applications across those two time periods. Increasing efforts or capacity, defined as the ratio of the number of completions divided by the sum of pending and new applications in the previous quarter, would be one way to reduce the backlog. Or in other words, if USCIS could complete more applications than are submitted in a given quarter, the pending backlog could be reduced. The effort ratio recently peaked in third quarter of fiscal year 2015 when 43% of caseload was completed, and experienced its lowest levels at 14% in the second quarter of fiscal 2017 and first quarter of fiscal year 2018. From the first quarter of fiscal year 2014 to the third quarter of fiscal year 2018, the average quarterly ratio under the Obama administration was 0.307, or 30.7% of the caseload completed, while it stood at 8.18, or 18% of the caseload during the Trump administration. While pending cases and efforts have shifted on average across the two most recent administrations, it is important to note that the start of the upward trend in the backlog and downward trend in effort predate the current administration, and there's little evidence of a reduction in the number of completions across those administrations. In other words, the backlog began before the current administration, but has also remained close to a 4-year high due to static numbers of completions in a given quarter. The new administration seems to be, at best, indifferent to the reality of Colorado's increasing naturalization backlog. The backlog presents an important hurdle to participation for otherwise eligible applicants for naturalization in Colorado's upcoming elections. For residents of Denver, for instance, an otherwise eligible applicant for naturalization who would assumably be granted citizenship would likely not be able to participate in the May 2019 citywide elections. And without a reduction in the backlog, more than half of those applying for citizenship in Colorado in February 2020 will not have their applications completed until after the 2020 national general election. Given that about 85% of applications for naturalization are approved in Colorado, and with 2,000 new applicants a year, roughly, a number close to current levels, this equates to approximately 1,700 people that would not be allowed to vote due to a backlog as opposed to their eligibility. On its face, longer backlogs in Colorado prevent some from voting in elections compared to alternative scenarios of shorter or less likely, and of course, the elimination of the naturalization backlog. The number affected increases as applications are submitted closer to upcoming elections. But to more clearly identify the effects of this backlog on voting rights, probability of voting among naturalized and in particular newly naturalized citizens should be addressed. If naturalized citizens tend not to vote, then the real impact is marginal. Now, a good deal of research finds that naturalized citizens register and vote at lower levels than their U.S.-born counterparts. Analyses of the November voting supplement of the current population survey from 2000 to 2016 suggest the same pattern holds in Colorado. In 2016, for instance, about 63% of naturalized citizens in Colorado reported voting compared to 83% of U.S.-born citizens. Those numbers are weighted to offset over-reporting, but still fall a bit above the actual 72% of the voting eligible population that voted in the election. But if over-reporting occurs at similar rates across these groups, the gap presents a valid measure of voting participation parity. Note also that the gap has actually narrowed since 2000. The registration rates exhibit the same gaps in participation, with about 90% of U.S.-born citizens compared to 73% of naturalized citizens reporting that they were registered to vote. And again, these numbers are high due to over-reporting, but are not too far off from the Colorado Secretary of State's registration numbers that indicate a 78% overall rate of registration. Once registered, however, the new gap goes away, with no discernible difference between voting rates found between voting rates among the registered across various categories of citizenship. Newly naturalized citizens are the most comparable to applicants in the backlog in Colorado, and thus their voting and participation rates are the best available indicators of future citizens' behavior. While the sample size of the CPS precludes election by election estimates, a pooled sample of respondents from the 2000 to 2016 election periods allowed for an estimation of the probability of registering and voting among the registered across groups such as U.S.-born citizens, naturalized citizens who migrated more than 20 years prior to the election, and naturalized citizens who migrated less than 20 years prior to the election, what I term newly naturalized citizens, while controlling also for age, racial, ethnic background, and election year. The estimated patterns based on that pooled sample of over 13,000 respondents closely reflect the expected patterns, with 83% of U.S.-born citizens, 72% of longtime naturalized citizens, and 60% of newly naturalized citizens reporting that they registered to vote while holding all their factors at their observed values, and those are Colorado numbers. These differences are statistically significant, and among those registered, however, or once registered, there's no difference across those groups in terms of voting rates. So based on these estimates, the common metric participation rates for the voting age population, or VAP, can be calculated. Newly naturalized citizens voted at a rate of 51.6% of the VAP. Longtime naturalized residents or citizens at a rate of 58.5% VAP, and U.S.-born citizens at around 72% VAP. Even with a range including a 10% discount for overreporting, new applicants resembling newly naturalized citizens would be expected to vote at rates of about 45 to 50% voting age population. Borrowing from estimated application approval rate, assuming an estimated application approval rate of 85%, which is roughly what Colorado's rate is, and a new applicant pool of about 2,000, again, roughly about the new applicants received in the most recent quarter where data is available, between 765 and 850 of those applicants would be expected to vote. Thus, even with low expected turnout among newly naturalized citizens, backlogs of any length preclude eligible individuals from voting. Opportunities for electoral participation by otherwise eligible voters notably varies by the processing time of naturalization. So to summarize to this point, the backlog in Colorado is growing, and on its face, such a backlog extends the length of time from application to gaining the right to vote. If processing times extend past upcoming elections, large portions of naturalized applicants, around 85%, who would otherwise be eligible to vote, are not allowed to do so due to administrative delay. The number of those affected varies by the number of applicants, but also the probability of new citizens voting once naturalized. Even accounting for these factors, hundreds of potential voters are likely to be denied the right to vote as election season approaches. This number would reach into the thousands if based on the number of applicants pending rather than new applicants per quarter. At 9,000 pending applications, with 85% expected to be approved and a voting rate of 45% on the low side, the number of aspiring naturalized citizens likely to vote in Colorado lies just at over 4,000. The effects of delayed voting rights on election outcomes cannot be directly estimated due primarily to limited data on voting preferences among all naturalized citizens and newly naturalized citizens. However, surveys conducted by Latino Decisions, a leading polling firm specializing in Latino political behavior in Colorado in 2012 and 2016, do provide representative samples and thus insight into the potential preferences of Latino naturalized citizens who make up roughly 35% of naturalized citizen voting age population in Colorado as of 2015. Focusing just on presidential choices, naturalized Latinos in Colorado reported voting for the Democratic candidate at rates just above 90% in both 2012 and 2016. By contrast, 87% of U.S.-born Latinos in 2012 and 81% in 2016 reported voting for the Democratic candidate. And in the statewide election outcomes, 51% of the vote in 2012 and 48% of the vote in 2016 went to the Democratic candidate. Latino naturalized citizens is the largest segment of naturalized citizens in Colorado, exhibiting a clear preference for the Democratic candidate in these years, which diverged significantly from the state's election outcome. So at least among Latinos, applicants awaiting completion of the naturalization process are likely to support Democratic candidates to a greater extent than the state as a whole. But it is not clear if speeding up the process would alter election outcomes in the state. Even with intense preferences, the number of applicants and their modest propensity to vote, register and vote, means that any shift in electoral support toward the Democratic candidates is likely to be marginal at best. In conclusion, the backlog raises significant concerns about its effect on the ability of applicants to participate in upcoming elections. Given the processing time and assuming it remains constant over the next year, substantial numbers of otherwise eligible and likely voters will not be granted citizenship in time to participate in Colorado's general election in 2020, and certainly not in local elections in 2019. It remains unclear whether the backlog is intended to dampen voter turnout, as the effects on election results are likely small and the number of application completions remains static over the last 4 years. Administrator effort has simply not kept up with the increasing number of pending cases and the number of new applications. What is clear is that in Colorado alone, without stepping up the number of completions, hundreds and potentially thousands will have to forego participation in upcoming elections due to administrative backlog in the naturalization process. Thank you.
Okay, thank you, Mr. Prose. Now I will turn to the committee members and ask if any of you have any questions that you would like to ask any of the panelists at this time. Helen? Or me?
Sure. This question is for our two attorneys, Ms. Cain-Rios and Professor Eastman. As you know, the Colorado Advisory Committee advises the U.S. Commission on Civil Rights, and we have a particular jurisdictional responsibility to investigate whether constitutional and statutory rights are being infringed. And so I wanted to ask, based on your legal expertise, whether the current practices that you're hearing about are compliant with the U.S. Constitution, in particular the Equal Protection Clause and the Due Process Clause, and in terms of possible statutory violations, either the terms of the INA, whether or not, for example, naturalization is in fact a right or if it is a privilege, and possibly the Administrative Procedure Act in terms of any denials or deprivations there.
So one of the things that I like to do when I talk about what naturalization means in the context of the statute is to emphasize that it is not, it's not discretionary. So there's nothing in the statute for naturalization that provides for discretion in deciding a naturalization application. Either someone's eligible or they're not. And so I think that's an important place to start in understanding the way that, that the statute is structured and the way naturalization procedures should continue. I think that it's also important to understand where there is some wiggle room in thinking about whether there is discretion in the officer's adjudication of an application for naturalization. So I think where we're seeing that wiggle room happen is with the interpretation of how much understanding of the English language someone needs to demonstrate during the interview. I think we're seeing it in terms of the interpretation of what is enough documentation and enough of a disability to not have to demonstrate the English or the literacy, the English literacy or the civics requirement for naturalization. I also think we're seeing it in the wiggle room in how good moral character is interpreted. So good moral character is has lots of different factors. Many of them are specifically in the statute. There's a statutory definition of good moral character. And it is elaborated in the regulations. One of the things that my colleagues have pointed out in the increase in either requests for additional evidence or in seeing denials and the reason for denials that they see as in individual cases, a lot of it has to do with the interpretation of how much evidence someone has to provide of their current good moral character. Most of the time we're talking about within 5 years, because that's the general statutory requirement, has a person been and continues to be a person of good moral character. There are complex considerations going further back than those 5 years, but the statutory requirement is a person must be of good moral character during the statutory 5-year period. In the regulations, there are several different portions that are that open up the possibility for interpretation of what someone has to do and what documents they need to provide to show that they're a person of good moral character. One of the subpoints in the regulations has to do with unlawful acts, and it's actually something that we as practitioners are seeing come up again and again in requests for evidence or potentially in denials. So with an unlawful act, you don't need a conviction. Okay? With an unlawful act, you're often asked to provide evidence of contemporaneous extenuating circumstances to overcome a potential interpretation that you are lacking in good moral character because of that unlawful act. So oftentimes we're talking about problems related to tax compliance, or whether it has to do with an unlawful act outside of the statutory period, or we're also seeing questions come up about use of benefits, and that is something that kind of ties in with the proposed regulations regarding public charge and kind of the confusion and concern that that has created in the immigrant community and with immigrant advocates, and the implications related to that. So that's a little bit of insight into. So I see the problem with the statutory and regulatory wiggle room.
I really appreciate that, and Jennifer is much more in the weeds on how the process works than I am, but I think there are a couple of very important things to get on the table. One, as I know you know, but a lot of people don't, the fact of the understanding of English requirement in the federal statute would itself raise red flags on equal protection problems for most people. And if were the states doing that, we would subject that classification to heightened scrutiny, strict scrutiny in many cases. But at the federal level, dealing with immigration thing, we apply rational basis review to that category. None of the reports that I've seen suggest that in the wiggle room on application of the understanding of English that there is a disparity by race or national origin group on how that is applied. It's not like the old voting literacy tests in the South, when if you walked in and you were white, you got asked who's the President of the United States. If you walked in and you were black, you got asked who was the king of ancient Macedon in 1732 BC, right? I mean, these were different kinds of things, and I've not seen any indication that kind of thing is going on. What we have is kind of the normal bureaucratic response to restrictions. And I want to tie this back to the length of the form or the change in the forms issue that's occurred. So, for example, the application to register for permanent residence, the I-485 form, increased in size, but there are a bunch of statutory requirements and categories in which you are seeking to apply for that status. The old form lists 6 of the categories and then said other as a just catch-all. There are 27 different categories, and the new form lists all 27, so that we're getting, and that doesn't mean it takes you longer, you just have to go down the list and know which box to check. But that kind of information is now more closely tracking the statutory requirements. Again, I'm not aware of any study that says immigrants applying for permanent resident status or naturalization, that there's a disparity in the processing times from, tied to or correlated with the nation of origin. I think you would need that kind of information to even begin to assess whether there's an equal protection problem. And to my knowledge, we don't have that.
I have 2 questions for Ms. Rao. Thank you for a very detailed description of the whole process, and I've been through it myself. My first question is, you mentioned you did the USCIS think 17 months, the processing time 17 months is typical. They will not consider it's past the processing time unless it's beyond the 17 months. And you also mentioned during a survey of your bar, association, that the majority of the lawyers reported that majority of the cases are finished between 11 to 17 months. So they're completed within that time frame that USCIS expected. does that mean majority of the members do not consider backlog? Is it, is there a backlog, based on the survey and your own practice? That's question number one. Question number two is, you also mentioned that some cases are processed, even nowadays, some cases still process much faster, like within 3 months, and you handled one of case like that. And then at the same time, some cases are processed much longer. Based on your experience and also your conversation with the fellow lawyers, what's the contributing factor to some cases get you processed faster, some process longer? Do you see any race-based, or is other factors, like you mentioned a lot about the English proficiency, does that have a lot to do with it, or the completion of paperwork? So can you elaborate on those?
So the actual question about English proficiency and the backlog, I think, is I don't see a connection with that at all, honestly. I think that the issue about whether or not someone is, so that a delay regarding English proficiency would come into play either at the interview and then the subsequent steps after the interview, right? So I think that generally when we're talking about backlogs, I think many of us, when we're talking about the published processing times of 11.5 to 17.5 months, we as attorneys have to use that as a tool to ask, to say whether or not it's time to ask for help or not, right? So if our clients' cases are not pending longer than that, we don't have recourse other than the federal courts through mandamus, right? So my experience is that many of the cases that are being processed now, as opposed to a couple years ago, are being processed at that year mark, right? And some of them are way beyond that year mark. Many people come to me after they've already filed and have gone to an interview and are like, oh my goodness, I'm way over my head. What have I done? What have I gotten myself into, based on their experience at the interview, being asked questions that they think are, really not related to the 5 years of statutory eligibility and all of the things that should be looked at, right? I think one of the things that I've seen and my colleagues have seen is that cases that are pending for longer periods of time, a significant reason for that, as we see it, is because the Immigration Service is taking a tremendous amount of time and expending a lot of resources to look at all the way back to the basis of their green card and examine whether or not there was some sort of mistake that happened along the way, whether it was a mistake that could be considered a innocent misrepresentation, or a mistake in whether or not they were technically eligible or not, or whether or not they should have asked for a waiver of inadmissibility but didn't. That's actually something that we're seeing play out with grants in front of the Immigration Court of Lawful Permanent Residence, and then USCIS looking back at that determination by the immigration judge when they naturalize, to say, we don't see it that same way. So we have a case like that, and it's something that that brings up a lot of concern about retroactivity and uncertainty. So again, I think when we talk about processing times, understanding what the published processing time means in practice for people is that unless that published processing time really tracks with people's experience and whether or not it's reasonable. Is it reasonable that that things are pending for a year or 18 months when a couple years ago there were cases that were done in 6, done in 3? So, generally the processing time that I see with most relatively straightforward cases without issues right now is around 12 months. But I have people who come to me later whose cases have already been pending for a year or more, go to their first interview and realize, oh my goodness, We need to look into this. And then the amount of time it takes to look back at what happened before, if they don't have a complete file of everything that they did or had an attorney help them before, we have to use the Freedom of Information Act to ask for those records. And that takes months and months and months and months. And then we get responses in portion. Great swaths are redacted. If things were processed in front of the immigration judge, then there are large portions of documents that are considered to be immigration and customs enforcement documents that USCIS won't release in that first release. They're completely blank pages. We have to wait several more months for ICE to respond to get that information, to be able to do a complete evaluation and say, okay, this, oftentimes we can anecdotally figure out what we think is going on, but we won't get documentation to confirm what our legal analysis until many, many months later because of the issues with delays with the Freedom of Information Act and with the agency, the different agencies not cooperating in releasing information.
I wonder if I could follow up on that. So you're saying you have a client who's applying for naturalization and say came to the United States 20 years ago, got a green card, and within the discretionary process these days, the naturalization officers will say, well, we want to not only know about your past 5 years, which maybe that's fairly straightforward, but we want to look back and make sure you were properly given a green card in the first place. And then the question is, where are the documents for that? And they're in the custody of the government. And the only way to get them out of the government's custody for the individual whom they affect is to file a FOIA request.
That's correct.
And it'll be redacted.
So it will be, so with all of the exemptions that FOIA has, they'll redact, especially if we're talking about relationship issues. So if we're talking about, if the person has been a lawful permanent resident for 15 years, but their original green card was based on a marriage that ended,
Right.
And there was a subsequent marriage to that, so maybe their marital history, because all of that's on the N-400, it goes all the way back. How many times have you been married? Not just in the past 5 years,
Right.
but your whole marital history. If there are questions about the basis and that first marriage, there will be problems getting documentation that does not belong to the applicant, to the individual. So besides the issue of things being redacted because of who owns the records, there is a question of not having access to documents that the USCIS would have, but the applicant would either somehow have to recreate them, especially if they didn't have an attorney who kept a complete file. They'd either have to recreate them or wait for the FOIA to come through.
Does USCIS have the discretion to say, oh, you don't need to send us a FOIA? We'll just, since you're applying, that's not their choice.
No, and actually, so my recent experience with someone who went to their first interview without representation and then came to me afterwards, and we went to the second interview, and that interview was videotaped. So that would be considered the equivalent of a sworn statement. I'm actually glad it was videotaped and it wasn't a sworn statement, because oftentimes sworn statements are kind of piecemeal and aren't as complete and accurate as we would like them to be. We were told at that time that all we had to do was send a letter and we don't have to FOIA the videotape. It's still pending beyond the 120 days. We requested information about the status and we're told that it is pending, and that if I want the videotape, we need to FOIA it. So a FOIA is already in, so I'm guessing that when eventually we get the FOIA results, that videotape will, come with it, but I'm expecting it'll be at least another 4 months.
So for a naturalization applicant to say, could I just have all of my immigration records that you have on file, and I'll pay you for your time that it takes you to dig without having to go through a FOIA, that would require a statutory change. Is that correct? Mm-hmm. Okay, thank you.
Yes, that's correct.
Are there any other questions? Okay.
I have a question for Dr. Pruz. Thank you for running all of these numbers for us and tailoring it to Colorado specifically. I noticed that in the statistics you provided to us, you mentioned that the voting patterns of newly naturalized immigrants were all controlling for racial, national origin. I don't know if you mentioned religion, but other backgrounds. And I wondered if you knew from your other studies or other literature if there are any significant differences in the voting patterns, both in terms of that would include information about racial and national origin in particular, those subgroups. So partly it's about those categories, and then secondly, partisanship in terms of the direction of the votes that are cast.
Right. So most of the information's on larger groups. So and the patterns break down. I guess it's expected for me into the literature. So non-Hispanic whites are most likely to vote and register, and you can go down the line. African Americans about the same. Once you start moving into other racial ethnic groups and the information on naturalized citizens is less clear, partly because of sample size and just an effort in some ways. Then we go into Latino population groups and Asian population groups, which actually tend to be at the lower end, in some cases surprising given particularly second, third generation socioeconomic status, which tends to be on par with white non-Hispanics. So that's the general pattern, and that seems to hold even within naturalized citizen populations.
And partisanship?
And partisanship also, yes, it differs as well. For the most part, as you go from white non-Hispanics tend toward majorities in supporting Republicans or partisan affiliation of Republicans. African Americans, of course, on the other end of the spectrum in terms of Democratic affiliations. Democratic affiliations or partisan affiliations. And then Asian and Latinos. Latinos tend to be more Democratic than white non-Hispanics, but not as much as African Americans, and Asians tend to be more Democratic, but again, not quite as Democratic oriented than Hispanics, but more so than white non-Hispanics. Now, a caveat to that is that many naturalized citizens also are much less likely to identify with a party, and so there is a nonpartisan context that's important to kind of consider, although voting patterns tend to be pretty consistent with what we would expect from partisans.
Any other questions?
Yes, thank you so much for everyone's testimony. We've heard some talk of swing states during today's sessions. Does it strike any of you as a credible theory that immigration backlog is being intentionally directed toward specific parts of the country that may be more important for electoral college purposes? Is there a way that policy would come down from Washington, D.C., and certain states would get the message and therefore increase immigration backlog? It just strikes me as a very aggressive theory, and I'm curious whether it's credible for any of you.
I think there's a couple components that would have to be there to make it make sense, right? And so on one level, we'd have to see swing state backlogs at higher percentages than other state backlogs, particularly with large naturalization, naturalized citizen or populations or potential populations. So I don't know what that looks like, but my understanding is that California, which is certainly not a swing state, has expanded, their backlog has expanded greatly, as has New York, which is not a swing state. And Colorado's has as well, and so I don't know if there's a sense of a direction or a relationship there. And I think another effect or another part of those hypotheses would be that we would expect large impacts in terms of electoral influence, right? And I think the bigger issue right now is whether or not it's targeted, is that there are these folks that are eligible to vote and otherwise can't vote in elections, right, just on its face because of the delay. But the other idea would be that if you anticipate a large swing in the vote outcomes, that would be away from your preference, essentially, towards the Democrats. And we would expect a swing from naturalization voting patterns and the polling opinion and public opinion data that we have. But those numbers are relatively small in each state. And so from Colorado's perspective, I think when I was on side calculations I didn't talk about just now, less than 0.6% of Hillary Clinton's margin, right, would be accounted for if you included, if you got rid of the entire backlog and then assumed everyone voted towards the Democratic candidate. So it wouldn't have shifted the election. So I think in terms of those elements, if it is intended, or if there is an impact, my sense is that, if it's political, there's a lack of concern because any rectification of that backlog would hurt you, right? If it's intentionally, right, that is that you really want to ensure that there's a longer backlog, I'm not so sure the case is there, or it's just really bad political science in terms of understanding what the impacts are going to be, right? So my sense is that it's less of a political ploy, right, to stop people from voting, and a bit more of a reality that that there's not the intent or effort, because if it does if the backlog is reduced, it's not going to help us either, right? But again, I don't know if those are the fundamental concerns, more so than just the basic notion that we have 1,000 people in Colorado that probably aren't going to be able to vote in the next election because of the backlog, and otherwise would be.
Let me add to that. One of the things I've seen in the data, there's a fairly consistent trend line on the increase in the backlog, which suggests that there's not any deliberate manipulation going on. Now, you'd have to disaggregate that into the regional offices to see if, in fact, some regional offices were reducing backlog and others that covered swing states were increasing backlog to be able to make that case. But the disaggregated data, I've not looked at it at that level with that question in mind, but it doesn't look like it's any different than the normal trend lines in the increase in backlog. There is something interesting, though, in the data that I noticed. Historically, there's a large increase in naturalization applications in the year leading up to a presidential election. It's kind of like I did when I waited too long to apply for my renewal of my TSA pre-check. You end up with a government shutdown and you don't get it in time. But historically, there's been a drop-off in those number of applications in the year following the presidential election. Oddly, that didn't happen this last cycle. And part of the increase in backlog to the historic levels we have is a result of that not alleviation of the pressure from the very large number of applications during the pre-presidential year. It didn't tailor off, and so there wasn't the opportunity to catch up with the same amount of resources. I don't know why that is. Lots of speculation about it. But that's much more directly relevant to the increase in backlog than any claim that this was a deliberate increase, I think. Because the number of applications is not within the control of the bosses at the USCIS.
Although that was not the pattern in Colorado, where we actually did see that drop-off and a spike before the election and then a drop-off afterwards, and then a continuing with the backlog. So there is some variation there, right? I don't know if it speaks to intent by any means, but that typical pattern we did see here in Colorado.
Professor Eastman, you actually just almost answered what I was going to ask you, because in your presentation you mentioned that the number of naturalized citizens in terms of absolute number actually reached a historical high. But then you also mentioned about the backlog issue. I kind of asked the same question I asked the previous panel. Do you think part of the factors or reasons for the increased backlog is because there's increased demand for naturalization? So even though in terms of absolute number, we actually we approve more those applications, but at the same time, you look at the percentage because you have such a bigger number and not tailing off.
Yeah, so there are a couple of possibilities here, and I think it warrants more study to try and disaggregate the number. Obviously, if you're processing applications at the same pace, but you get a lot more of them and you don't get additional resources or employees to help, the backlog is going to increase. If one administration is more carefully applying the statutory requirements than a prior one without additional resources. That would lead to an increase in backlog as well. If there is a difference in the regulatory regime or the statutory regime that adds new mandates without adding new resources, and we've seen some of that as well, that would increase the backlog and also decrease the efficiency ratio of the people, reviewing those applications, because they would have more to do in the same amount of time, and so that would increase the backlog as well. There is some combination of all three of those things going on, I suspect, and how much fits within each bucket, it's a little hard to tell.
And I would actually look at it in a very different way. So on the ground, I think that, and knowing that the resources come from filing fees, the great majority of the resources for USCIS come from filing fees. Where is that money going? Who is assigned to conduct interviews, and how many people are doing those interviews in Denver these days? How many interviews are conducted in a week or a month? And how many people are working with extreme vetting efforts, with FDNS, with fraud detection and national security, which is part of USCIS.
Yeah, and I want to elaborate on that point a little bit, because I think it's important. In the latest USCIS report to Congress, they acknowledged that they increased the fees, but that it was not enough to cover the increased number of applications. So they're filing for, and that didn't make a whole lot of sense to me. Because if the fee is tied to how much it costs us to process your application, and it's costing us more to the application, the increase in fee ought to cover it. So I agree, there's probably some reallocation of resources, or a greater focus on the fraud component, which could be just the emphasis of the two different administrations being different. If the prior administration was a little more lax in making sure there was compliance with each of the statutory requirements, and this new administration is being more faithful to that, or being more concerned about fraud about it, and I think one of the things with the increase in forms we see on all of the forms is there's a lot more information about the preparer and the interpreter and their licensing authority and what have you. I suspect that's tied to requests, investigation for fraud. Who's processing all these things? Are they doing it legitimately? And if they're not, do we have the information that's necessary to go find out from them? And so that's a different law enforcement emphasis that may be having a direct result on the backlog as well.
Okay, thank you. I do have one question, Ms. Kane-Rios, that you had mentioned that you often do file mandamus cases. I was just curious to know, how successful are those cases?
So I can't comment personally on filing mandamus cases, because honestly, I'm a sole practitioner, and filing federal lawsuits is very resource intensive. There are, I want to say, a handful of firms in the Front Range area that do them, and my understanding from the responses is that the great majority of people who responded to the question, have you filed a mandamus, is no. And the question to, are you interested in doing it, is the great majority say yes. Not as many as say no, because everybody recognizes that it's a tremendous financial burden for immigrants to file a federal suit. And it's an incredible use of resources for a law firm to take on federal litigation. And as a sole practitioner, I know that I can't do it. But if I have a client in a position, I know who to refer them to. And it is oftentimes a matter of, is there enough harm that you can document right now, as well as undue delay, so unreasonable delay. Oftentimes, is there a reason for mandamus to, is there reason for the federal court to order the government to act, not necessarily approve or deny, right, but act, make a decision, because you will be harmed by it. So that's the mandamus question. I can't personally respond to that, but I know who to refer people to if they need to consider that. And oftentimes it's financially prohibitive.
So I guess related to that question, are you familiar with any court making a decision as to what would constitute reasonable time between the biometrics date that's, when that occurs and then when the first interview is conducted?
So that's not really the consideration,
Okay.
at least in the 10th Circuit. And I have some general information about mandamus from kind of a nationwide perspective, and I'll see if I can reach out to some of those law firms who do federal litigation to maybe have them comment and include that information within my additional testimony in the next 30 days. I'll see
Okay.
what I can do.
Okay, thank you. Are there any other questions, committee members? All right, well, I would like to thank all of you for your time today, and again, encourage you all to submit a report in writing to us for consideration that we can also reference. At this time, we'll break for lunch and reconvene at 2 o'clock with our panel 3 presentation at that time. So again, thank you. Okay, good afternoon. We'll go ahead and reconvene now. So we are going to open up our panel 3 discussion on the remedies for the backlog. Today we have Christy Goldinger, District Director of the U.S. Citizenship and Immigration Services, Bryce Downer, Immigration Attorney from Novo Legal Group, and Jamie Torres, Director from the Denver Office of Immigration and Refugee Affairs. So right now what we've been doing is we're providing 15 minutes to each of our speakers to present on this issue and just speak to the committee. The committee members will then have an opportunity to ask questions. So we'll start with each of the speakers first, and then once that's done, then we'll ask you questions directly. So let's go ahead and start with Christy.
Oh,
Thank you.
Well, first of all, thank you for your invitation here today to provide insight into the USCIS processing times for Form N-400, the application for naturalization. U.S. Citizenship and Immigration Services remains committed to timely and accurate adjudications. Additionally, we remain focused on process improvement and employee development while at the same time combating instances of fraud, abuse, and other activities threatening the integrity of our nation's immigration system. USCIS experienced an increase in the number of pending naturalization applications and subsequently experienced elevated N-400 cycle times. Both are the result of higher than projected applications received in fiscal year 2017, which actually you heard a lot about in the previous panel. Projected volume for the receipt of new N-400 applications was 853,292, while USCIS actually received 986,460 N-400s, which is 13.5% higher than we anticipated. Unlike previous presidential election cycles where receipts dropped by 14% in the year following the election, receipts actually increased from fiscal year 2016 to fiscal year 2017. In fiscal year 2017, USCIS received more than 9.1 million application and petitions, approximately 4% more than the prior year, and exceeded projections by 4.6%. Also in fiscal year 2017, USCIS received almost 360,000 family-based green card applications, exceeding agency projections significantly. Despite the increase in receipts overall, USCIS has been able to increase N-400 application completion levels over those prior to fiscal year 2016 without sacrificing the quality of our adjudications. In fiscal year 2018, USCIS approved the most naturalization applications since fiscal year 2013, resulting in 849,393 new citizens. Currently, USCIS is completing citizenship applications more efficiently and effectively and remains focused on meeting not a 6-month processing goal, but our target is a 5-month processing goal for Form N-400. Receipt levels in Colorado follow generally national USCIS trends. The Denver field office, which serves Colorado and part of Wyoming, so I had to warn you in advance that I couldn't delineate Wyoming from Colorado, but by far most of our receipts are Colorado. So the Denver field office received 11,158 applications for naturalization in fiscal year 2017 and 9,053 applications during fiscal year 2018. During fiscal year 2017, Denver completed 7,600 applications for naturalization and increased that number to 9,437 completions during fiscal year 2018. Denver's cycle time peaked at 12.9 months in June of 2018. As of December 2018, which is the last month we have for accurate data, Denver reduced their cycle time to 10.7 months. For the first quarter of fiscal year 2019, this year, Denver completed 3,121 applications for naturalization, putting Colorado on track to have a processing cycle time of 5.6 months by the end of this fiscal year, which is in September, and further on track to reach a 5-month processing cycle time goal during the first quarter of fiscal year 2020, which would be between October and December of this calendar year. Denver has been able to lower the processing cycle times of naturalization applications through additional staffing and process development. In relation to the increasing workload in Colorado, Denver has received additional staff at a rate equivalent or slightly higher than the national USCIS field office directorate average. In fiscal year 2016, Denver was authorized 63 positions. In fiscal year 2017, the number of authorized positions increased to 68. In fiscal year 2018, Denver had 74 positions. And currently, for fiscal year 2019, Denver is currently authorized, and we are aggressively hiring to reach and maintain a staff of 82, of which 48 are immigration services officers. We have 4 more officers to hire. Overall, this represents a 30.16% staffing increase. In addition to increased staffing levels, USCIS has authorized overtime and initiated redesign efforts to lower cycle times by identifying process efficiencies and quality enhancements. In FY 2018, Denver completed the majority of its paper-based naturalization cases, and by the third quarter of fiscal year 19, the officers will be adjudicating all the naturalization applications hopefully quickly, through our online electronic processing system, whether filed electronically by the person or using a paper application. In addition, certain immigration benefit applications filed in Colorado were relocated to other field offices within the Rocky Mountain District for final adjudication in order to improve the capacity of the Denver field office to focus on naturalization applications requiring interview. As a result, in fiscal year 2018, officer productivity in the Denver field office increased 16% when compared with fiscal year 2017. In June of 2019, Denver will implement the new information modernization model, which will provide additional capacity to address backlog cases in Colorado. By implementing these varied approaches to improving capacity and efficiency, USCIS will effectively reduce cycle times in Colorado and will continue to do so throughout this fiscal year. Before I close, I do want to highlight that our progress in relation to naturalization processing times is not at the expense or quality of our family or employment-based adjustment of status applicants. During fiscal year 2018, the Denver field office achieved a rating of 100% for decisional accuracy on Form N-400, a level of quality that reflects the pride that my employees take in our work and in our mission. Similar to the naturalization processing times, the family-based adjustment of status processing cycle times are decreasing, and we are committed to reducing that processing cycle time to 5 months within the first quarter of fiscal year 2020 in parity with the Form N-400. Denver also works to ensure that employment-based applications are interviewed and adjudicated consistent with the timeline in which applicable visas become available. Thank you for your time, and after all the speakers, I look forward to any questions you might have.
All right, thank you. The next speaker on our agenda is Bryce Downer. Go ahead, Bryce.
Thank you. First off, I'd like to start by thanking everyone here today, ladies and gentlemen of the Colorado Advisory Committee to the U.S. Commission on Civil Rights for the invitation. It is my pleasure to be here and offer whatever insights I have that can be meaningful. I'm an immigration attorney. I've been practicing nearly exclusively in immigration naturalization for the past 7 years. Most of that has been here in the Denver area. And I do a lot of work with naturalizations and applicants for naturalization here in Colorado as well throughout the country in conjunction with labor unions. And so we'll regularly travel, our firm regularly travels specifically for the purpose of N-400 applications and adjudications. First off, there is a backlog in the adjudications of N-400 applications. And that was thoroughly discussed earlier today, the earlier panels. As far as my purpose here in discussing the remedies, I'm happy to go over all of the remedies that are available to general applicants that are pro se or with attorneys that represent them. But in conclusion, my opinion is that the remedies that exist are entirely insufficient to really address the nature of the backlog. In short, I believe that the backlog is a problem that was born out of the Department of Homeland Security and can really only be addressed by the Department of Homeland Security in reallocation of its resources. That's not a ding against the department. But current remedies for an individual who has applied for naturalization include, right now, filing a service request. That service request is to be made either by calling the 1-800 number or making an e-request online at www.uscis.gov. However, really, in order for that service request to be beneficial to the applicant, it has to be beyond the processing times. Otherwise, anecdotally, the only response that you really get is the application is currently processing and pending within the average processing times. Please wait. And currently, as USCIS has stated, that their processing times nationwide are 17 and a half months. It offers very little information to the applicants here right now. Info passes were an opportunity that an individual or an applicant would have to go to USCIS, the Denver field office here, and discuss that with an officer. That would offer insights to the applicant, or at least some face time with an officer to explain to the applicant what is going on and what is happening. However, as of October 2018, it was announced that self-scheduling of info passes will no longer be available, as that is part of the modernization. I forget the actual
Information modernization.
Information modernization, thank you. And so that is being done away with. I can say that for the past several months, even prior to that being announced, it's been difficult at best to schedule an info pass to discuss the case or a pending case with the USCIS officer. Before that, individuals would have applicants would have an opportunity to, if represented by counsel, have their counsel reach out to USCIS. Here, specifically in the Denver area, we had an email that was available to allow for a form of communication with the Denver field office that no longer exists. AILA Colorado previously also maintained a liaison as a form of communication that happened quarterly with USCIS Denver field office, which is no longer available. Outside of that, an applicant may file Form 7001 with the Ombudsman, and that's essentially like a step up to a service request. the ombudsman office, first off, they ask that that the applicant files a service request prior to approaching that office and filing that form. And when you have filed that form, essentially that is being now reported as likely being outside of current processing times, with an inquiry being submitted once every 3 months. That is from their office. So very similar to a service request, which an applicant would have to do once every 3 months. Outside of that, the legal options that exist for an applicant, you have 8 USC 1447 subsection B, which allows for a complaint for naturalization. That is very similar to a writ of mandamus, but very specific for naturalization applications. However, this statute, it does allow an individual to file this in federal district court. Now, a little background is that since the passing of the Real ID Act, it's become increasingly more difficult for applicants to seek review of agency decisions in federal district court. This is one of the exceptions, but the statute says that it has to be filed only after the interview has taken place and only after 120 days post the interview if a decision has still not yet been made. This does not address the concern for applicants who have filed their initial application and have not yet received an interview. This is for individuals who have filed it, received an interview, and still have not yet received a final adjudication. Outside of that, you have to become a little bit more creative as to your options, and I would say definitely requires a legal basis and a legal understanding of the legal process, which most pro se applicants do not possess. And that would be trying to be creative in filing mandamus actions. Now, this would be mandamus action similar to the statutory one that I previously cited, but this would be to try to encourage or have a federal district judge order the agency to render a decision, to fulfill with its obligation to adjudicate. That can be difficult. I can tell you that my firsthand experience, though, is that I've rarely had to come to decisions on that, in part because the Attorney General's office will generally reach out to to the agency and will discuss what is going on, and shortly after we will receive an adjudication from USCIS prior to a final resolution, and so essentially it becomes moot, the petition filed in federal district court. I can say, though, that in many of the instances where that has been an option, I have had more clients choose not to exercise that option for fear of reprisal or fear of an application being denied based on that. And I will state that I don't think that fear is necessarily well-founded, but I do believe that it is very much real to them, and that they are concerned that if they do that it'll be viewed negatively in adjudicating their application, and so they'd rather just wait, albeit at times to their prejudice when it comes to not necessarily having proof of their lawful status, and so an inability to travel outside the United States or to change employment, things of that nature. There's an option. I have a colleague, her name is Danielle Jeffries, and we work closely together on this issue, and we've been working with labor unions on this as well. They've addressed that they're very concerned, as they've had thousands of members file applications that are still pending. And we've discussed potentially a Fifth Amendment action of due process issues based on the fact that an individual has paid for this benefit, and there's an obligation under the APA which requires the agency to resolve these adjudications within a reasonable time frame. That is found, the reasonable time frame language is found under 5 USC section 555 subsection B. Generally, it's difficult, though, to define what is reasonable, what the reasonableness is for that time frame. And that, I think, is one of the reasons why, in part, we are here today. What is truly reasonable? And I don't necessarily, I'm not the one to necessarily state what that is, but I can say that in 2000, Congress did pass Section 8 USC 1571, subsection B, in addressing then the current immigration backlog of just general applications that were pending before the INS. And they passed this section which says that generally their thought is that applications should be adjudicated and resolved and concluded within 100 days of the initial filing. So if we look at that section, I would say that Congress has established generally their intent that anything outside of this 180 days initial filing is outside of normal processing times or what they would expect to be reasonable. However, federal courts have looked at this as somewhat, let's just say, as a goal to be reached, but not necessarily something fixed when concluding what is truly reasonable. There have been several federal courts that have ruled that, well, at least they know for sure that 2 years is unreasonable. In those decisions, they don't delineate when the pendency of an application transitions from reasonable to unreasonable, but in those cases that have been presented, they were pending for about 2 years. And so they said that was the line there for sure. But still, we don't know. I can say, though, that my impression is that since the passing of the Real ID Act, that generally federal district courts are somewhat reluctant to wade into the realm of immigration, understanding that that is generally the realm for the agency. There's also, like I mentioned earlier, due process. As an individual, an applicant is paying for this benefit, that the applicant would potentially have a due process right, that the fees that are used, that were increased 2 years ago, that the fees that are used in paying for that application be used in the adjudication of that application and not necessarily for other purposes by the agency. We have currently been filing FOIA requests that have requested information as to why there is such a backlog, asking information about the allocation of fees, filing fees, the reallocation potentially of filing fees, and enforcement or fraud and investigation. We have yet received any of those responses, but we are planning on potentially taking those and litigating those responses and redactions once we receive them to determine whether or not we feel that there is a good faith basis in pursuing lawsuits against the government. That is essentially all I have right now, but I look forward to answering any questions.
Thank you, Mr. Downer. And at this time, I'll turn the time over to Jamie Torres.
Hi, everyone. Thank you for having me. I'm in an interesting position, especially when it comes to remedies, because we look and what kind of falls to our radar tend to be very big picture. A little bit of background. My name is Jamie Torres. I'm the director of the Office of Immigrant and Refugee Affairs for the City and County of Denver. I've served in this role for 13 years. Our primary focus is ensuring that Denver is a city that welcomes immigrants, that ensures that we're a city that's an accessible partner in their integration journey. Our immigrant population comprises about 15% of our overall population, which is about 100 to 105,000 immigrants in Denver. We've partnered with Colorado Immigrant Rights Coalition for the America is Home grant from the National Partnership for New Americans. I believe both were here earlier today. This in an effort to encourage eligible legal permanent residents to apply and to help them do so. We have over 30,000 estimated legal permanent residents in the City and County of Denver eligible for citizenship. In our metro area is over 65,000. We began by trying to understand why our residents do not apply for citizenship and conducted a qualitative study in 2015 with a student from the University of Colorado at Denver in the School of Public Affairs, solidifying common barriers that I think most of us assumed going in, which included the cost of the application, confidence in English skills, and the complexity of the process seeming scary. But the surprising factor for us was that The primary reason most folks did not apply was because they did not feel welcome to become citizens. And this was mentioned more often than even the other barriers. And this became something that we felt we could do something about in terms of public perception, in terms of our welcoming nature as a city, and really trying to redefine some of the rhetoric around being a city that welcomed folks to become citizens and to take that step. Supporting our residents' naturalization process, however, is something we've been long a part of. We host ceremonies and offer resources that help them prepare. We just want to make sure that residents can find accessible routes through the process. I think you've heard today the numbers, so I'll skip a bit of that. I think in terms of remedies, what we're looking at really translate to big picture. So less an analysis of the Denver regional office and more of how USCIS may operate in total. But curiosities typically. Did USCIS properly project numbers in preparation for annual application numbers? In 2016, they projected a caseload of 775,000. The reality was 25% more. In 2017, they projected a caseload of 853,000. The reality was 16% more. USCIS has indicated they plan to hire additional staff. What we're curious about is whether or not that staff will be there to help clear the backlog. In 2019 budget for Department of Homeland Security, a fee funding transfer from USCIS to ICE in the amount of $207,000. Reallocating that fee revenue from ICE back to service-oriented adjudication is one remedy. In terms of policy changes, I think we've looked at a number of different things that could be different in requirements for folks, particularly when it comes to English and civics portions of the test, exempting eligible LPRs from those if they demonstrate graduation from a high school after completing academic grades 6 through 12 in the U.S. and their curriculum reflects knowledge of U.S. history, government civics, and English, and expanding exemptions for certain elderly applicants. At a congressional level, I would be interested in asking Congress to assess plans that USCIS has announced or proposed that would change the eligibility landscape for applicants, including changing fee waivers for lower income immigrants, changing the naturalization application for asking more expansive questions, including 10 years of travel records as opposed to 5, a new overhaul of fees in 2019, and requiring more documentation like birth certificates, which many refugees may lack. One of the things that's been a real success marker for offices like mine around the country have been routine and regular coordination with like offices in other cities. I'd like a little more information, even on how our district offices connect to one another. Because of national information that some offices are going through their applications much more quickly than other offices. I know everything has to do with population and the amount of applications received, but coordination, communication between them, even recognizing that and communicating that out to the public so that we know what those issues might be, so we know what that coordination might be, would be helpful. In 2006, when USCIS worked their way through a prior backlog of naturalization cases, they provided quarterly updates. It would be good to see that again. In terms of local remedies, local communities are working to provide more legal consultation to applicants to ensure there are no gaps, mistakes, missing information prior to submitting the application. In 2017, we created an Immigrant Legal Services Fund, which delivers grants to local legal service providers to provide, in addition to defense representation, also affirmative relief legal assistance to low-income immigrants in Denver. This is something that we self-fund. It is fundraised. It is also catalyzed by city dollars. But one thing that we recognize is that more and more Immigrants in immigration proceedings, whether they're affirmative or defensive, need a lawyer by their side, and this becomes an economic barrier. Millions of LPRs across the country want to become citizens. Their economic futures improve as do their communities. We've partnered with our regional USCIS office often to hold moving motivational citizenship ceremonies. We want to see their office and our communities succeed. We are willing partners in this work. We also want to ensure an honest, consistent, and deliberate process awaits applicants who take that bold and long-planned step to become citizens. Thank you.
Thank you, Ms. Torres. At this time, we will allow the committee members to ask questions. Is there anybody that has any questions for any of the panelists?
I have a question. Ms. Goldinger, if it's a birth certificate question, you have a person who was admitted as a refugee and they're applying now later for naturalization, and they don't have birth certificates for themselves or their children or anything because they're refugees. How does your office deal with that situation?
That's not a required document in the naturalization process. However, in other processes, that is a requirement, and when you do not have a birth certificate, there are alternate documents that are acceptable. Mostly we get that information from the Department of State, up to and including affidavits on behalf of family members who may have witnessed the birth. So there are alternate documents.
Okay, thank you. And you follow Department of State guidance on what's acceptable for as substitute?
Correct, the Family Affairs Manual.
Okay, thank you.
Do you want to go, Will? And then maybe afterwards. Okay.
Thank you, panel, so much. So today we've heard a few things that may be out there. One is that there is a backlog. Another is that the backlog might not have enough attention paid to it. Another is that the backlog might be intentional and that it's increasing due to intent. And another might be that part of that intent is political. And even further, that political intent may be based on where in the country votes may matter. In terms of those allegations, I'd be curious what the panel members think the truthfulness of any of those allegations or how credible they maybe are. And particularly Ms. Goldinger.
Could you say them one, and then I'll go through each of them?
Yeah, so is there a backlog? Is there enough attention being paid to the backlog? Is the backlog intentional due to political reasons? And are those political reasons being pinpointed throughout the country based on the impact of how naturalized citizens would vote?
Okay, when you ask the question, is there a backlog? Our target is 6 months. We are currently at, what did I say? 10.7 months. It puts me in a comfortable position to know that our production plan is going to be able to be executed.
So you feel you have you are at the optimal staffing level then to
Yes.
address the backlog?
Yes. And when I tell you that we are going to hit 5.6 months by the end of this fiscal year, I wouldn't have said it if I wasn't comfortable.
Just one follow-up. We heard testimony earlier this morning that within some communities there's a lot of fear right now about applying for citizenship or about maybe one member of a family applying and another member of the family being subject to deportation. Is that consistent with the rising number of receipts for applications? Or is the theory that it would be even higher without the fear? I'm just wondering how we reconcile, on the one hand, the idea that people are generally afraid of maybe being subjected to the current administration's policies, and on the other hand, the number of applications is going up.
My comment on this is that both may be true in some varying form. We definitely see both to be true depending on which conversation we're in at the time. There is more fear about what additional questions, what farther look might be requested into somebody's history. There's still a lot of misunderstanding, I think, also about the process. And these are folks who do not have legal assistance when they're making these decisions. We still find that this is the case. That said, there are organizations and individuals that are more compelled to take on a citizenship application than they were 3 or 4 years ago. And that may be because of their own vulnerability or because they want to be more involved and they're seeing the outcome of engagement in civic process. So I think both of those could be true. We see them both in a given day, depending on the individuals that we're working with. We've got 30,000 people who are eligible, but we don't have 30,000 people applying. So there's, I think, both narratives.
It's my experience that in the past 2 years, there's been a significant, well, based on comments that have been made, be it tweets or be it policies implemented, such as a travel ban, that has served to agitate the community at large, and that agitation in general has led many individuals to seek forms of relief while other individuals to not apply, even though they are eligible because they are fearful. So I think they coexist, that you have some individuals. You have more people, though, I think, seeking legal counsel to understand what their rights are and what their benefits are, and what would happen if they were to apply for citizenship and be denied is a question that I'm receiving more now than I've received in the past. It seemed that in the past there was a general understanding that if they applied for naturalization and were denied, that that's fine. In the future, they could just reapply. I've had many more individuals approach asking, does this mean I've lost my permanent residency now, or does this mean that I'm going to be put in removal proceedings? And that is coming out of a place that I believe to be sincere fear for themselves or other family members in the household.
I actually have a question for you, Ms. Goldinger, regarding the statement about the national trend when there's an election that generally receipts will decline. And I know that you were here for a portion of the second panel discussion when Professor Pruiz did point out that that wasn't the case in the state of Colorado. And so given that you had the additional staffing that provided some support for what was needed to address the backlog, are there any other factors that you can identify that could have attributed to that, given that there was a reduction in receipts as opposed to the increase?
Okay, I'm trying to, can you repeat that? I'm sorry.
Sure. No, I like at the beginning of your presentation, you had mentioned the statistics about how you try to anticipate what priorities need to be made as far as staffing needs when it comes to receipts and when there's going to be an increase or decrease. And it seems that there's always been an effort to try to increase staffing to address the backlog and decrease it and to meet the goals that you've set for yourself as far as reducing the backlog to 3 or 4 months. My question is that given that, you had mentioned that the national trend is that whenever there's a presidential election, the receipts seem to decline, but that in this most recent election, they actually increased. So that when you thought that the staffing would provide...
Post-election.
Exactly.
Post-election, I'm sorry.
Sorry, can you not hear me? Or okay.
You're fine. I didn't hear what you said.
Okay. So my question was that Professor Pruiz had mentioned that that wasn't the case in the state of Colorado. So I'm just curious to know that if there was an actual decline in the receipts in the state of Colorado, it seems that if there's still a backlog and it's not being resolved, then there must be other factors that are attributing to the backlog rather than there not being sufficient staffing. I guess that's my question.
Right. During FY17, Colorado and Wyoming received 11,158 applications. That was significantly higher than USCIS projected for Colorado. And in fact, in FY20, 2018, we also, as far as USCIS projections, received more than we would be projected to receive. And every year we've gotten closer to what we in Colorado project we will receive to what we actually receive. You know, which is why I said this year we're very stable. We're within 5% of what was projected. But I don't know where his information came from. But I do know that 11,158 applications in one fiscal year for Colorado was a higher than normal rate of receipt and beyond what was projected for us. As far as the staffing levels, like I said, in FY16, which goes into 2017, we were at 63 positions, and each year we have needed more positions in order to get to the place we needed to be in order to address the needs that we have here in Colorado. I do believe that at a staff of 82, which includes 48 officers, that that level, given our projection trends, should stabilize us and bring our completions into the processing cycle timeframes that we need, barring any unpredicted surge, which we're not seeing right now.
Let me just clarify. I thought the chair was getting at the point that you would have expected an increase in applications in 2015, and that didn't happen, and nevertheless the backlog went up. So why didn't the backlog why didn't you catch up in 2015 when fewer cases came down than you would have normally anticipated in the year leading up to a presidential election?
In
So Colorado had
2015, our cycle times were good in 2015. And I didn't bring any 2015 data, so I have to apologize. I didn't bring that, but
I'm just looking at the professor's data that indicates that I believe Colorado had a counter trend, which is that we decreased before the election and then increased after the election, which I thought was the opposite of what's usual. So the idea I thought was, why wouldn't you catch up on backlog if you had more people in anticipation of an election and then the numbers didn't pan out?
the trend is to increase before an election because people want to vote. And then post-election, you see a decrease. In this instance, in this cycle, we saw an increase pre-election, and it did not decline post-election. And I don't know specifically when he was, I haven't actually read his data that clearly to be able to speak that specifically to it, but that was what we saw. And normally you see receipts go up before an election because they want to vote, makes sense. It usually happens somewhere between 6 to 9 months before the election, and then after you get a kind of a drop off. And in this one, post this election, we did not see the drop off that we normally see. People kept filing. And so when you do projections out, you think you're going to have this high period for it, but then after that you think there's going to be a low period. When that low period doesn't come, if you have 5 months, you get beyond that 5 months, and then you have applications that you haven't been able to address.
Okay, thank you.
We've had a lot of discussion, both up here among committee members and with panelists, about the amount of resources that are being allocated to USCIS, both externally as a matter of the user fees providing the larger chunk of the budget than the more typical congressional appropriations, and also in terms of what is happening internal to the agency. So my question is more about what's happening internal to the agency, and specifically beyond looking at the total amount of funding, if you can give us any insights into the allocation of that funding. So for example, in the increase in staff, whether the staff are necessarily being assigned to adjudications and other kinds of immigrant services, as opposed to other functions or programs. I think a more pointed question was raised earlier from one of the panelists about whether or not certain funds were being allocated from adjudication specifically to fraud detection and other enforcement-related programs, the Denaturalization Task Force being among them. So aside from just looking at the lump sum, the dollar amount, can you give us any insight into the allocation of that funding and that staff?
Fraud detection and national security is a part of USCIS, and so therefore it is part of the user fee goes to support that program. That said, fraud detection and national security is a directorate within USCIS. That is not Immigration and Customs Enforcement. It is not. It is the group of people who vet any national security concerns that come within our applications or any type of fraud concerns that would lead to administrative disposal of the case. Well, for instance, you hear the term marriage fraud sometimes, if it's suspected marriage fraud. That would be looked into by our fraud detection and national security. So they are a part of USCIS, and it is part of our mission to detect and deter fraud within the application petitions submitted to USCIS. And they are the part of USCIS that addresses those concerns.
You know, I was reviewing the 2018 budget proposal for USCIS, and I had noted that there was a 50% increase for the fraud detection, and it would appear to be a much lower increase for adjudications. Questions that I have that I think other individuals that address this backlog are wondering about is where do the funds come from to fund that, if that is a reallocation of funds of the filing fees for N400 applications or other applications, operations such as Operation Janus, the denaturalization program, is that being funded through application filing fees for N400 applications? To my knowledge, I've tried to dig quite a bit into that, and I've been unable to understand if that is actually being funded through the filing fees or if that is through the appropriations. Because 99% of, I believe it's 99%, it comes from filing fees of the funding for USCIS, it seems to me that that would be coming from filing fees, but I don't have any knowledge as to that, but we filed a FOIA request to that.
I will add that in addition, when I talked about the growth of Denver, we have also had growth in our fraud detection and national security because proportionate to the cases that needed attention are those cases. So since FY16, we have gone to 5 to 12 immigration officers who work fraud detection and national security case in order to address and close and to address those pending cases.
And if I may as well with that, when it comes to the adjudication of the N400 applications, it seems that in any other industry where you have the business or the agency that is being funded through the filing of applications, that if you're receiving a significant increase in applications, that means therefore you are receiving an increase in funding, and that increase in funding should then be reallocated to servicing the demand that is had through the increase in applications, sufficient to meet that demand. And it seems that in this case, for the past couple of years, that hasn't been true, that we're now reaching that, but there has been an increase in filing fees that was increased. The amount of the fee for each application has increased, as well as the number of applicants. So if those filing fees are not going to increase the amount of adjudicators or quickly enough, where did that money go?
Okay, do any other committee members have any further questions?
I have one question. Ms. Goldinger, as you probably remember from the morning panel, some of the panelists talked about the process of communicating about naturalization applications And I think that to simplify, they said in the good old days, you could send an email or a fax or other things, but now that's been kind of constricted to essentially the voicemail system that has some of the frustrations that lots of big voicemail systems have, or you can send a letter that may not get a response unless it's after the application's a year and a half old. I was wondering if you could comment on those issues in regards to your office.
Sure. Those avenues of communication were exclusive to the American Immigration Lawyers Association. And we no longer give preferential treatment to any organization. When we have our meetings, they are open to everyone, and we have, and so yes, so ALA used to have their own email box. ALA used to have special services. They are now directed to the same services that all applicants have. And our meetings are open to all applicants. So anyone from ALA can come, or anyone who happens to see a flyer or a poster or a janitor can come to our meetings and hear the same things that we say, and we will post it. We got to the point where we were talking about our work more at the cost of doing our work. And the more time we do things outside of the national structure, which is to contact the customer service number. And you know, the way it works is if you call this number, and if that case goes to Denver, basically it goes into our queue and we answer it, but we answer it through email. So while I do understand that we don't have special services anymore, we provide more consistent services to everyone, regardless of who you are.
Great. Thank you.
Are there any other questions that anybody has? And I just had one point of clarification. So the numbers and figures that you gave, was that only specific to Denver, or did that include Denver and Wyoming?
It includes Colorado and parts of Wyoming.
Okay.
However, because the Denver field offices services the state of Colorado and about 75% of Wyoming.
Okay, so all the
However, I will let
staffing.
you, Wyoming filings are very small.
Okay. All right, thank you for clarifying that.
You're welcome.
All right, at this time, I think we've come to the end of the panel 3 discussion. So we would like to provide some time to Dean Anaya, who has come and offered to share some words before we go up into the open session. I would like to invite panelists to stay for that session. It's just an opportunity for anyone here to make a statement, as I've outlined earlier in the meeting. So you're welcome to stay for that session as well. But I would like to thank you, panelists, for participating. I appreciate your participation today. And again, you're all welcome to provide written statements as well. We can provide you with information on how to submit that, because once we prepare our report, it's helpful for us to cite and reference to those statements. So please, we welcome that as well. Thank you again.
Thank you.
All right.
Hi. Good afternoon, everybody. My name is Jim Anaya. I'm the Dean of the University of Colorado Law School, and it's my pleasure to welcome all of you, members of the Colorado Advisory Committee, to the U.S. Commission on Human Rights, on Civil Rights, and to all the panelists and the participants in the audience. I'm a human rights expert, so I usually say human rights as opposed to civil rights, but I do know that it's the U.S. Commission on Civil Rights. I understand that there's been a rich discussion and expert testimony on the important issue of the backlog of applications and naturalization and citizenship. And this is, of course, a very important issue, and it relates to the kind of concerns that we deal with day to day here at the University of Colorado Law through our immigration policy program. We also have a student group on immigration concerns. And more generally, of course, at University of Colorado Law, public service and public interest matters are core to our identity and what we do, again, on a day-to-day basis. So this is very much in keeping with our tradition of public service and examining important issues of public interest. So again, welcome to all of you, the panelists, and to the members of the Colorado Advisory Committee to the U.S. Commission on Civil Rights. You know, in our country, we have a fairly developed, as you all know, set of laws dealing with naturalization and citizenship. But of course, the hard part is seeing those laws adequately implemented to the benefit of those for whom those laws are directed. And so to that end, I'd like to acknowledge all of the panelists for their work, diagnosing the causes of complicated problems and examining its consequences for all of us. I'd especially like to acknowledge and thank the closing panelists for their perspectives on what to do about the problems that have been addressed and how to solve them, including Christy Goldinger. Christy, welcome. From the U.S. Citizenship and Immigration Service, Jamie Torres from the City of Denver Mayor's Office. Thank you for coming. And the immigration attorneys and community leaders from like Bryce and Danielle and so many others from earlier in the day. I'm told that you were given the hardest job of the day, the panelists. Also, I'd like to acknowledge the representatives of the U.S. Commission on Civil Rights, Barbara de la Viez and Evelyn Bohor. I hope I said that right. And I understand you'll be relaying the feedback of the panelists and the public here to the commissioners of Washington, D.C. Thank you all for being here. And thanks to the members of the Colorado Advisory Committee to the U.S. Commission on Civil Rights for volunteering your time to study this important issue, including Alvina Earnhardt, the chair, David Koppel, the vice chair, and Professor Ming Chen, who is really the driving force behind the organization of all of this. We're very proud of the work that Professor Chen does on immigration and policy matters and for bringing this event to the University of Colorado Law School. We're very privileged to have Professor Chen's work and this event along with it. Finally, I'd like to acknowledge the Colorado Law students, Zachary New, Nicole Soto Quintero, and the Immigration Law and Policy Society, as well as our staff, Wei-Joan Adun, and our events, who's our events coordinator, and Teresa Coberly of our IT department, with whom we cannot do anything around here. All of them have provided behind the scenes support that is essential to the success of this event. And they'll continue to assist in the final stages of this event. So in closing, it's been a privilege, a genuine privilege to having all of you here with us, to having the Colorado Advisory Committee to the U.S. Commission on Civil Rights be part of the life of our law school. Thank you so much for coming. Thank you.
All right, thank you so much. At this time, I believe we will take a 15-minute break, and then we'll reconvene with the open session. So, thank you. Our open session at this time, so we have several individuals that have signed up to read statements. The first person that we are going to hear from is Anastasia Del Carpio.
Hello, good afternoon. My name is Anastasia Del Carpio, and I am an immigration attorney with Lutheran Family Services. Lutheran Family Services is one of the refugee resettlement agencies here in Colorado, and within the refugee resettlement department, we have a legal services department, and I am the attorney who leads our naturalization program. So our program director asked me to come and speak to the committee about kind of who are we serving and what trends have we seen in our processing times for naturalization since I've been with Lutheran Family Services, which is about summer of 2015. So because we're a refugee resettlement agency, I would say a large portion of our naturalization clients, about 70% approximately, are refugees or asylees. And the countries that are most commonly represented are Burma, Democratic Republic of Congo, Sudan, Afghanistan, Iraq, Eritrea, and Ethiopia. Of our non-refugee naturalization clients, I think we see a lot of representation from Mexico, Central and South America. Since I've started, when I first began in summer of 2015, I watched our processing times fall pretty dramatically. We had a lot of our cases being processed in 3 months from the date of filing to the date of interview. And that lasted until probably late summer of 2016 when we started seeing that processing time uptick a little bit. For a while, it was holding pretty steady between about 6 and 8 months for most of our applicants. And then starting in 2017, we saw it steadily increase. We got up to an average of 12 to 14 months for a lot of our applicants. I will say in the last probably 2 to 3 months, we've seen that drop a little bit to closer to about 10 months for a lot of our applicants. And so that's just some of the trends that we're seeing with our particular population. I also just wanted to note that I thought with panel 2, Professor Pruis, his discussion about new citizens and their demographics and their sort of trends in which party maybe they tend to lean to as a general group, and their potential impact on elections was really interesting. And I thought his point that if the sort of leaders in the executive branch are making decisions about the backlog and processing times and how many resources to dedicate to naturalization based on that kind of perception of how are these new citizens going to impact us and my party in the election, that wouldn't really be based on good political science, which I thought was a really interesting point. I also think it may be worth exploring as, discussions about different racial and ethnic groups and how they tend to vote comes up so much in our elections, to consider whether that, even if it's a small consideration, it doesn't have a huge impact in an election. If it's one of the considerations that people who are higher up in the executive branch are considering when they're determining how many resources to give to naturalization processing. And if that is happening, if that's one of the things they're considering, like, is that appropriate, and are there ways to maybe protect that decision from that political decision making. And those are all my comments today. Thank you.
Thank you. All right, the next individual we have is Claudia Castillo.
Hi there. Mine is kind of twofold. One is actually personal. I'm first generation, which means that I am the first to be born in the United States. My parents came to the United States from Mexico, and they were undocumented for a large percentage of my childhood. Thanks to what we call now the Reagan amnesty is how my parents were able to gain status to be a lawful permanent resident, and then their citizenship. So as a child, I can tell you the effect that it's having on children now, because I lived it. So the fear that my mother and father, even though they were lawful permanent residents, were still going to be taken away from me was still very real. And currently, in my role as a legal services coordinator for the Colorado Immigrant Rights Coalition, is what I continuously see in the children today, is that it's a constant fear. Even if they're lawful permanent residents, there is nothing in immigration law that protects anyone once they apply for citizenship until the day they take the oath at their ceremony. There is nothing that protects them from anything that extraneous that may happen to them. Myself, growing up in 4th Ward, Houston, Texas, very crime-ridden area. Let's just say that the police were not very friendly. So at any point, my father could have been stopped, my mother could have been stopped and cited, and that could have led to deportation proceedings. So it's the same way with some of the children that we see today. So I'm asking is that the impact that it has on the entire family just upon the processing time of this application. Another question that I think I wanted to answer is, what is changing in the community from what we see, whether they're applying or not applying? And I see a very rift. About a 50% will not apply because they are afraid that somehow something that they did prior to the 5 years or even prior to them receiving their residency is going to actually be detrimental to their case, and they would be deported and lose their residency. The other 50% that I'm seeing that are coming in is because they've never felt the fear that they feel now and the way that the community is targeted. So before, someone's been in the country for 20 years. They never needed to become a citizen. They were safe, also they thought. So now with the way that the administration does target the immigrant community, there's a huge fear. And now LPR is not a safe haven, which is very true. It's not a safe haven. What I did see as a child when my parents went from residents to citizens, and in the entire circle of our, not blood family, but family that we made while we were in the States, is that almost every single person began their own business, which is huge for an immigrant to come here. My father was, I guess what they call a gilder. He polished antiques. So he had his own business. All of a sudden, someone's getting their landscaping business. All of a sudden, someone's getting a construction business. And it kept rolling through the families once they could receive their citizenship. So I do say that, yes, lawful permanent residence is something that they have to go through before citizenship. It doesn't protect them. And in the wait time could actually hurt them and their families. But then once upon gaining citizenship, it really opens up so many possibilities that they didn't think they had before. Because as a resident, they still felt like everything could have been taken away from them immediately. As a citizen, now they knew that justice was on their side. Thank you.
Thank you. At this time, we don't have any further individuals that have signed up for the open session, but if there is anybody in the room, please, we welcome your comments. We'll be receiving comments until 5 o'clock today. So in the meantime, I guess we'll just wait and see if anybody signs up, but you're all more than welcome to speak if you have anything to share, and that will be included in the record as well.